Criminal Court 10. The 30th Judicial District of the State of Tennessee is now open for the transaction of business pursuant to adjournment. All persons having business with this court draw near, give attention, and ye shall be heard. The Honorable Judge Jennifer Johnson Mitchell presiding. You may be seated.
Good morning. Any business we need to take care of before we bring the jury in?
No, Your Honor.
Evans, you'll be up first.
Yes, Your Honor.
You can bring in the jury. Ladies and gentlemen, before the jury comes in, I will start to read this jury charge very soon. There will be no movement during the charge. The door will be locked. Nobody will enter and nobody will exit. It's going to take me about 15, 20 minutes to read this charge. So if you don't feel like you're going to be able to sit still during this time frame, please exit now. Thank you. Call your first witness.
Your Honor, the defense rests.
Okay. Ladies and gentlemen, you have heard the proof in this matter. What you have had in your seats, is a jury charge. This is my portion of this trial. It's the law. Now, the law states that I have to read it to you. Please don't think I am insulting your intelligence by reading to you. I know you can read for yourself, but the law states that I have to read it. You all have to read it at the same time. Okay. That is your copy. Feel free to write on it. I have the official copy here that will go back with you to the jury room. I cannot write on this copy, but feel free to make any notes that you'd like to make, and any changes that I have to make that I see that need to be made will be made on the official copy. Okay. State of Tennessee versus Justin Johnson. Members of the jury. The evidence in this case has been completed, and it is now my duty to instruct you as to the law. After I instruct you as to the law, the state and the defense may present their closing arguments. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. Duties of the court and the jury. The law makes it the duty of the court to charge the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them in the trial and under the law given them by the court, render their verdicts with absolute impartiality. No sympathy or prejudice by the jury. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdicts. You must render your verdicts with absolute fairness and impartiality as you think justice and truth dictate. The indictment in this case is the formal written accusation charging the defendant with the crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdicts should be. Statements and arguments of counsel. Statements, arguments, and remarks of attorneys are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made by the attorneys in this trial at any time that you believe are not supported by the evidence, you should disregard them. Along these lines, the opening and closing arguments of the attorneys are likewise not evidence. You must base your decision in this case on the evidence that was actually presented in this court, not on the statements of attorneys. Furthermore, the questions the lawyers ask the witnesses are not evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is true. Jury, judges of facts and law. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of this court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in light of your own observations and experiences in life. Presumption of innocence. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Reasonable doubt. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element necessary to constitute the offense. Crimes charged and pleaded. The first count of the indictment charges the offense of conspiracy to commit first-degree murder. Embraced and included within the offense are the lesser included offenses: facilitation to wit, conspiracy to commit first-degree murder. The second count of the indictment charges the offense of first-degree murder. Embraced and included within the offense are the lesser included offenses of second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. The third count of the indictment charges the offense convicted felon in possession of a firearm. The court will now explain to you the law applicable to count 1 in this indictment. Conspiracy to commit first-degree murder. Any person who conspires to commit an offense is guilty of a crime. For you to find the defendant guilty of conspiracy to commit first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained, and that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder, and that each party acting for the purpose of promoting or facilitating the commission of the offense of first-degree murder agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder, and that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of this conspiracy. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement that they be completed is abandoned by the person and by those with whom the person conspires. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. Abandonment of a conspiracy is presumed if neither the person nor anyone with whom the person conspired does any overt act in pursuance of the conspiracy during the applicable period of limitation. If an individual abandons the agreement, the conspiracy is terminated as to that person only if and when the person advises those with whom the person conspired of the abandonment, or the person informs law enforcement authorities of the existence of the conspiracy and of the person's participation therein. However, mere presence is not sufficient to support a conviction. Facilitation to wit, conspiracy to commit first-degree murder. Any person who commits the offense of facilitation to wit, conspiracy to commit first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of conspiracy to commit first-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the conspiracy, and that the defendant furnished such assistance knowingly. Conspiracy to commit first-degree murder has been defined on page 4. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances, or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable in count 2 in this indictment. First-degree murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and the defendant acted intentionally. A person acts intentionally when it is the person's conscious.
Grace and peace. Good morning, everybody. Good morning. We got a lot to do today. So I wanted to start off by showing you the Young Dolph case. First of all, the Young Dolph case is over. It only took a week, which is crazy. That already blew my mind. I was like, wait, hold on. How are y'all already done? I had intended maybe next week to kind of do like a highlight reel. Ain't no highlight reel. Like literally the whole case is over. That's crazy. But I see a lot of people asking about the RICO charge because they actually mentioned RICO in here. We have another summary of this where I do believe this is in my opinion, a textbook example of a RICO case. You got the crime, you got the conspiracy, and you got a whole bunch of money. There's a lot of money that's going to be involved in this. So she's not talking about it. This judge is not referencing it, but there's a lot of money that was being spread around. And I think when you compare it to what we have here in Atlanta in the YSL trial, it becomes very clear. Yeah, this YSL trials is RICO deficient, to say the least. But let's go ahead and finish this up. And I want to, it's not actually finish up, but they're still going through it. And then we'll come back in and talk about it. So let's go. Let's go. Good morning to everybody. Let's go.
Conscious objective or desire to cause the death of the alleged victim, Adolph Thornton Jr., and that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted knowingly. Knowingly means a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Facilitation to wit, first-degree murder. Any person who commits the offense of facilitation to wit, first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of first-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense. And that the defendant furnished substantial assistance to that person in the commission of the first-degree murder, and that the defendant furnished such assistance knowingly. First-degree murder has been defined on page 8. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, second-degree murder. Any person who commits the offense of facilitation to wit, second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of second-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit from the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the second-degree murder, and that the defendant furnished such assistance knowingly. Second-degree murder has been defined on page 9. Knowingly means that the person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted intentionally or knowingly, and that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions, which renders the mind incapable of cool reflection. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant intentionally or knowingly caused bodily injury to another, and that the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, voluntary manslaughter. Any person who commits the offense of facilitation to wit, voluntary manslaughter, is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of voluntary manslaughter, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the voluntary manslaughter, and that the defendant furnished each such assistance knowingly. Voluntary manslaughter has been defined on page 13. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Any person who, facilitation to wit aggravated assault. Any person who commits the offense of facilitation to wit aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of aggravated assault, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the aggravated assault, and that the defendant furnished such assistance knowingly. Aggravated assault has been defined on page 14. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Simple assault. Any person who commits a simple assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant caused bodily injury to another, and that the defendant acted either intentionally, knowingly, or recklessly. Facilitation to wit simple assault. Any person who commits the offense of facilitation to wit simple assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of simple assault, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the simple assault, and that the defendant furnished such assistance knowingly. Simple assault has been defined on page 8.
All right. I don't mean to interrupt the judge because she's crushing it. She's doing a great job this morning. I just wanted to give you an opportunity to see and hear how what I believe is a much better run, much more fine-tuned RICO. Well, actually, I'm sorry. Let me back that up. They use the term RICO very early on, and they're not really committed to it. And I'm going to show, we're going to look at another video that explains this one might not be a RICO. It is the gateway to RICO, if you will. I'm going to use that term. It's a gateway to RICO because some people have mentioned it. And the next video I'll look at does really kind of dig into and get into the deep weeds, if you will, of what was the actual crime, who were the players involved in it, so on and so forth. So I thought this would be a good one, especially since all of us have, we've been looking for RICO. We've been wondering where RICO is. I think RICO is in Memphis, Tennessee. So I know most of us are like, look, RICO ain't in Fulton County. I concur 100%. I think RICO is in Memphis, Tennessee. And I think this was a good example. If y'all want, we'll finish, but she's still reading. I didn't realize how long this was going to be. She's still going over the jury instructions at the moment. And there's looks like at least 10 more minutes of it. If y'all want, I'll definitely tap back in. Let me real quick just say good morning to everybody. Thank y'all so much. Here in Atlanta, don't worry, we're safe and dry at the current moment. There's no real problems or anything like that. I think it was just drizzling earlier before I came into the studio. but now I don't think it's bad at all. It was, pretty rainy last night, but nothing terrible that in my neck of the woods. I haven't left the house yet. Me and the girls have been in the house all day. And Lady Dear World Christian, she's at a business conference and she's safe and sound. So she'll be coming back Saturday. So everybody's good here. There we go. Now, I appreciate all of you all, and my intent was to kind of talk about this young Dolph case a little bit later because I thought it was going to be going on a little later. Yikes, I was wrong. I was totally wrong. So that was crazy that this thing literally has been a week. This case has been a week. But if you do the comparison, some of the elements of this case are so much more fine-tuned than the case against Young Thug and YSL that it's almost laughable. It's sad to see because good and well, just like me, this Young Thug case is going to be going on for some time. I did not think the Young Dolph case was going to get done that fast. I thought at least it'd be a month, not a week. So here we are. Now the jury's going to get the case today. Who knows? Maybe they'll come back on Monday. Maybe they'll come back this afternoon. I don't know. So that's going to be wild. But I'm going to bring this back in. I appreciate all of y'all tapping in. I appreciate all y'all tapping in this morning, hitting the like button, joining the best live chat on the planet. We're gonna bring back in the tap back into the Memphis case and see how it finishes up, and then we'll talk about it. We got a lot to go through today, so let's get at it, Jason. Let's go.
18. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable to count 3 in this indictment. Convicted felon in possession of a firearm. Any person having been convicted of one of certain specific felonies who possesses a firearm is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant had been convicted of a specified felony, and that the defendant, after such felony conviction, possessed a firearm, and that the defendant acted either intentionally, knowingly, or recklessly. Firearm means any weapon that will or is designed to or may readily be converted to expel a projectile by the action of an explosive. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. If you find from the proof that the defendant has been convicted of another crime or crimes than that for which he is presently on trial, you may not consider such evidence as proof of his disposition to commit the crime for which he is on trial. The defendant has pled not guilty to each and every offense charged and included in the indictment. Direct and circumstantial evidence. One type of evidence is called direct evidence and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. Accomplice. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. You should consider all the evidence presented in this case by the state and by the defendant and give it full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors: how the witness looked, acted, and whether the witness appeared to you to be telling the truth when he or she testified. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Whether the witness was in a position to know about the matter to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard? Whether the witness's statements were consistent and how believable the statements were. Whether the witness had a motive to testify truthfully or to testify untruthfully. And any proof presented of the witness's reputation for telling the truth. All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Another factor for you to consider in evaluating the witness's testimony is whether the witness has made material statements at some point before he or she testified, which are different from his or her testimony at trial. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of any prior different statement may be considered by you only for the purpose of determining if the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. Criminal responsibility for conduct of another. The defendant is criminally responsible as a party to the offense of first-degree murder if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Intent means that the person acts intentionally with respect to the nature of the conduct or to the results of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. To find a defendant criminally responsible for the acts of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Absent material witness. When it is within the power of the state or the defendant to produce a witness who possesses peculiar knowledge concerning facts essential to that party's contention and who is available to one side at the exclusion of the other, and the party to whom the witness is available fails to call such witness, an inference arises that the testimony of such witness would have been unfavorable to the side that should have called or produced such witness. Whether there was such a witness and whether such an inference has arisen is for you to decide, and if so, you are to determine what weight it shall be given. This inference does not apply to the defendant because he has a lawful right not to testify, and his failure to testify cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Defendant not testifying. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Stipulation. A stipulation is an agreement between the parties. The parties have stipulated that certain matters of fact are true. They are bound by this agreement, and in your consideration of the evidence, you are to treat these facts as proved. The parties have entered into two stipulations. The parties have stipulated that Adolph Thornton Jr. was a living person who is now deceased, and an autopsy was performed to substantiate these facts. The parties have also stipulated to the fact that the defendant, Justin Johnson, is a convicted felon, previously convicted on May 2nd of 2017 in Division 8 of the Criminal Court of Shelby County. Flight. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community, or leaving of the community, or parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the facts of flight. If flight is so proven, together with all the other evidence when you decide the guilt or innocence of a defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. Multiple counts, finding of each required. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charge must be stated in your verdict. Jury deliberation and unanimous verdict. The verdicts must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdicts must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Notes. If you have been taking notes in this case, these notes are for your individual use only, and you should not use your notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. Deliberation, order of consideration. In reaching your verdict, you should first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. That is the law, ladies and gentlemen. We will now proceed with closing arguments.
Okay, I'm gonna jump in before they start closing arguments. So thank y'all so much. Lots of people just jumped in. I appreciate y'all. We are looking at the Young Dolph. Let me pull it back up. We're looking at the Young Dolph murder trial in Memphis, Tennessee. I wanted to just compare some of the things that we've been hearing in the YSL trial against this young Dolph trial. Now, I think it's very super interesting, and we're going to look at it in a moment. There's a summary. If you're not familiar with the young Dolph, don't worry. I'll bring you up to speed. I will get you there. Don't worry. But I just thought it was super interesting, and I was watching this. I said, "Oh, it's almost time for me to go on. Let's all watch it together." So I thought it was extra interesting. Hey, those are the jury instructions. Now, granted, you might not have wanted her to read them to you, but you do realize it only took her 20 minutes to read those. And the jury does have a copy of them. So they're reading it along with her, but she has to read them aloud. That's only 20 minutes. You know, like I know, the young thug jury instruction is going to take 2 days. You know it. You know it's going to take 2 days. It's going to be a mess because it's all over the place. Now, this trial is geared toward just one particular event, the deletion of young Dolph. Now, that's key because later on, they're going to use this case, and they've already said it, they're going to use this case as a stepping stone for a RICO of epic proportion. And the same characters that are caught up in this trial are going to be, that were named in this trial, are going to be grabbed by the short hairs, so to speak, for the actual RICO that's coming up. But we'll look at that as well. So let's look at the closing arguments. I appreciate y'all jumping into the best live chat on the planet. Shout outs to all the new subscribers and new members and new people that have tapped in. I really do appreciate you. My name is Jason. I live here in Atlanta, Georgia. I like to give social and political commentary from a Christian male perspective. I thought it'd be fun to look at some other cases. We got a couple other cases. I've seen some people even talking about them in the chat already. So we got a couple other cases since there's no court here in Georgia today because of the storm that's coming. They canceled court. So I figured we'd go ahead and look at some of the other things again. Memphis, there's something fun going on up there in New York. You know what? Before we even do any of that, we got to bring up the prophet. The beginning of the year, this prophet said something. I think we got to give him credit. Let's go. Bring him back in real quick, Jason.
It's all catching hell in 2024. It's up for all of them. It don't matter if you Diddy or whoever you is. All lies will be exposed. So if you and a man was in a corner doing something you wasn't supposed to be doing, you will tell it. I know so many things I shouldn't know. When I walk in a room, heads go down.
Cat Williams told us. This was back in February. Y'all do realize that infamous Shannon Sharp interview was in February. And my goodness, in the morning, that thing has not let us down. So now we're almost at the tail end of the year, and Cat Williams wasn't lying. Not lying one bit. We hadn't even talked about Diddy. I mean, we hadn't even got into the deep weeds of that. But let's finish up here the closing arguments of the young Dolph case. Definitely comment in the chat. Let me know what you're thinking, what your thoughts are. Let's get it going. Let's get back at it, Jason. Let's go.
Good morning.
Good morning.
So it's almost over, and I'm sure you all are happy. My name is Iris Williams. I'm one of the prosecutors on this case. And earlier this week, you heard opening statements. You heard opening statements from prosecution and from the defense attorney. And you were told all the things that you could expect this week. And one of those important things that you could expect was that it is not 1981 anymore, and that things have changed. But what does that mean? It means that it's hard to keep a secret. It's hard to hide who you're talking to. It's harder to hide your actions. And it's even harder to hide who you know. But ladies and gentlemen, despite all of those things that have changed, one thing has not changed, and that is the state's burden. The state's burden of proof is beyond a reasonable doubt. So what does that mean? Where are we? So the defendant, Justin Johnson, is charged with 3 counts: conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. So I know that you've already gone through a little bit of this law during voir dire, and especially through the jury instructions. But a brief overview of conspiracy to commit first-degree murder is that 1, this defendant entered into an agreement with 1 or more people to commit first-degree murder. 2, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acted for the purpose of promoting or facilitating the first-degree murder. And 4, 1 or more of the parties committed an overt act to help the crime happen. So what did we hear this week? This week, we heard testimony from co-defendant Cornelius Smith. He testified for us, and he told us that he met Justin Johnson through Hernandez Golan, and that he knew Justin was a rapper, and he was also known by the name of Straight Drop. So Smith had known the defendant for a couple of months, and they hung out a couple of times before the murder. He was able to identify defendant in open court, and during his testimony, Smith told us that on November 17th, 2021, he and the defendant knew that Big Jook had a $100,000 hit on Dog's head. Cornelius said that he and Justin agreed to kill Dog together, and both of them receiving $40,000 apiece. Not only did he tell us that, he told us that this plan had been in process for weeks, and that Justin knew about it. And there were conversations previously or prior to this murder, and Justin Johnson was an active participant in those agreements. So there we have it, a conspiracy to commit first-degree murder. An agreement was made. Each of the parties had the intent to commit the first-degree murder. Each person acted for the purposes of promoting, facilitating, and, ladies and gentlemen, the overt act is the killing. Next, first-degree murder. In essence, a first-degree murder is a premeditated killing of another. What's required for first-degree murder is, one, that the defendant unlawfully killed the victim. The only way to lawfully kill someone is if you are in protection of yourself or others. Second, you have to prove that this defendant acted intentionally. Intentionally means that there was no mistake, there was no accident. Third, you have to prove that the killing was premeditated. And as we saw, or as we learned in Ward Dyer last week, premeditation does not mean that you had to have this plan for months, weeks, or days in advance. It could just mean that you simply stepped out of your car, you held up your hand, you pointed a gun, and you shot and killed somebody. As long as you had a moment to think about what you were doing, that's premeditation. Next, so we heard from a couple of people this week. First, we heard from the victim's sister, Erica Thornton. She testified that the victim was a living person. He had a family, he had children. She's known him her entire life. She attended and planned his funeral service. And coupled with that, defense counsel and the prosecution agreed to a stipulation, which just means that they agreed to establish that this victim was a living person who was now deceased. Later on, we heard from Dr. Scantleberry. She was a medical examiner and performed the autopsy. She found that there was a total of 22 gunshot entry wounds, including gunshots to the back torso, front torso, head, neck, upper extremities, and vital organs. She also testified that on the property that was collected from the victim, there was no weapon. And we also heard from Raul Hawkins. He testified that he was head of Dolph Security for years. He was able to identify Dolph's car in the beginning of the Makita's video, and he was also able to explain the difference between CMG and PRE, their history of conflict, rivalry, diss tracks, and even prior acts of violence that were towards Dolph. So with all of this testimony, we've established that there was a killing and that the victim was Adolph Thornton Jr. But was that killing unlawful? Was that killing premeditated? And was that killing intentional? Back to Cornelius Smith. In addition to testifying about the agreement that he and the defendant entered into, he also testified about the killing. He said that on the day of the murder, the defendant picked him up from his father's house. They both knew that the victim was doing a turkey drive with several of his PRE artists. They also knew that Big Jook had a hit out on all of the PRE artists. So it was their job that week to find them. And on November 17th, 2021, Cornelius Smith and Justin Johnson were on their way to a turkey drive in Westwood. As they were about to turn the corner, they saw a familiar car cross the intersection, which happened to be Dolph's car. Cornelius tells us that they followed the car, made a loop onto a back street, and then entered the Makita's parking lot. And this happened, I want to say, about 30 seconds after Dolph and his brother arrived at Makita's. Cornelius Smith was able to point out himself in that video and the defendant in that video. And he said that both of them were the shooting suspects in that video. The second suspect that got out of the car was wearing a black hoodie, gray pants, black shoes with white soles, and a Bass Pro hat. The same clothing that defendant Justin Johnson was seen in as he was exiting his apartments at the Crosstown Concourse. After the shooting, Cornelius Smith testified that they got into the white Mercedes that they committed the act in. They went to Bradley Street. the defendant parked the white Mercedes on the yard and they both got into a white Ford Expedition. They both got into that Expedition, and on the way, a couple of calls were made, right? Cornelius tells us that a FaceTime call was made to Big Joe. In that FaceTime call between Big Joe and our defendant spelled out the word Dolph. And as they were on their way to the Gospel Gardens apartment, the defendant also contacted a few other people who we'll find out later on. So once the defendant and Cornelius Johnson arrive at Gospel Gardens, they receive wound care. They change their clothes, and then they go their separate ways. After they go their separate ways, Cornelius Smith tells us that he went to retrieve his phone and he went to go wipe down the car, the white Mercedes that was parked at Bradley. So with Cornelius Smith's testimony, we have established that the killing was unlawful. There was no evidence to show that this defendant was in fear, was protecting himself, or was protecting someone else. We also established that it was intentional. It's not an accident. You didn't mistakenly follow someone's car into Makita's parking lot and then shoot them. We also established that it was premeditated. They knew about this hit beforehand, and they committed this hit. So if that wasn't enough for you, we heard from some other people. We heard from Kirsten Gardner. He testified that he was present during the time that the defendant was able to get possession of the white Mercedes that the act was committed in. Kirsten Gardner was at the Valero gas station in the early hours of November 17th, 2021. Next, let me go back to Kirsten Gardner. After he testified that, he told us that he didn't know anything about what was happening the next day, or a few hours after the cars were switched. Similarly, Jamarcus Johnson didn't know anything either. He just knew that he needed a ride, and his brother, Justin Johnson, could provide that for him. So he got his car, the rental car, and he took his cell phone, he fielded his calls, posted on his social media, and checked his emails. After Jamarcus Johnson, we heard from Sergeant Dabney. He was able to tell us about the 4 different bullet casings that were present at the murder scene. .40 caliber, attributable to a handgun. .7.62, attributable to an assault rifle that Cornelius Smith had. .223, attributable to a semi-automatic that Marcus Thornton probably would have had. And a 9mm casing found inside the store, which could be attributable to the handgun that Marcus Thornton had inside the store. That first one, though, the .40 caliber attributable to a handgun, was in the hand of the suspect with the Bass Pro hat. So, Sergeant Dabney also recovered the surveillance footage from Makita's and Gospel Gardens, showing this suspect in the same clothing that the defendant was in as he was leaving his apartment at 10:49 a.m. that morning. The timestamps on Gospel Garden and Makita's coincide with the times defendant's phone accessed those towers. We heard from Special Agent Garner, who summarized that the defendant's phone accessed a tower that provided coverage to the Valero gas station at 3:17 a.m. Around the same time that Kirsten Gardner said that he saw the defendant take possession of that white Mercedes at the Valero gas station. The defendant's phone also accessed towers that provided coverage for the area of 2370 Airways Boulevard, which is our murder scene. And it accessed those towers during the times of the murder, 12:22 p.m. to 12:23 p.m. on November 17th. Officer Garner also explained that the defendant's phone accessed a tower in the area of the 2-lane road in Shelby Drive from 1 p.m. to 1:59 p.m., which is the direct correlation to the surveillance footage of Gospel Gardens and the footage that Officer or Sergeant Dabney identified the defendant being present for. So next, if all of that wasn't enough, we heard testimony from Sergeant Browning. Sergeant Browning said that this defendant's device placed an outgoing call to Anthony Mims at 12:25:40 p.m. on November 17, 2021. Not only did he place an outgoing call to Big Joe, he also received a text from Kiana Hooper, who is his cousin. She texted him an address of 4752 Haven Court. After he received that address, he then sent that address to an associate named Jermaine Sears. Jermaine Sears, or defendant's device, sends the outgoing text to Jermaine Sears that he needs him. And you'll see in the surveillance footage of Haven Court on that day, at that time, a car that is associated with Jermaine Sears arrived shortly after the defendant arrives in a white Ford Expedition. So the next thing, convicted felon in possession of a firearm. The three things that we have to prove beyond a reasonable doubt is that 1, this defendant was a convicted felon or convicted of a specified felony. And 2, after being convicted of a felony, this defendant possessed a firearm. And 3, this defendant acted intentionally, knowingly, or recklessly. So the facts that we have for this charge. Well, 1, there was a stipulation or an agreement. The parties have stipulated that defendant Justin Johnson was convicted of a felony on May 2nd, 2017 in Criminal Court 8 in Shelby County, Tennessee. Next, we heard testimony from Cornelia Smith, who verified that the person in that Bass Pro hat was Justin Johnson, and that person held a gun. So based on all of that, we can see that we have met our burden of proof for convicted felon in possession of a firearm. Next, let's just talk about reasonable doubt for one last second. Reasonable doubt, it is not 100% certainty. It is not beyond a shadow of a doubt. It is not beyond all doubt. What's required is moral certainty. Certainty that allows you to sleep well at night. Will you be able to rest easy knowing the decision that you've made? My instinct says yes. And once you've had time to deliberate, I think yours will too. So that brings us to the end. The state has met its burden of proof beyond a reasonable doubt. You have all the evidence, all of the testimony, all of the stipulations, all of the videos, all the photographs. And now it's time for you to consider that evidence and apply your common sense. And after you do that, I expect that you will find this defendant guilty on all charges. Thank you.
Thank you, Ms. Williams.
Thank you, Judge.
I can't wait to hear Adrian Love try to do that. I can't wait to hear her try to put together the story. It's going to be crazy. All right, let's go.
It's good to see y'all again. This is the last time you're going to have to hear from me. And as I see all of your faces, I know that's something you're looking forward to. And that's okay. I know that you all want to get back to your lives. And I can tell you on behalf of Mr. Johnson that your attention during this trial is greatly appreciated. What you've had to set aside in order to provide this service, I have no doubt that the court, and Mr. Hagerman, Ms. Iris, all of us agree you're indebted to you for that. Because like I said in opening, this is important. And you're about to have to roll up your sleeves and go to work. And it's going to be a difficult job. This young man's fate is in your hands. The concept of justice, right? We talked about that in Fort Dyer. We talked about that again in opening, right? And it's in your hands. Meting out justice. And it's difficult because what you've heard is the tragedy of someone losing their life, of their family members not having that person in their life. And that is terrible. And the court will tell you, as terrible as that is, you can't consider that when you're determining guilt or innocence in this case. But it's heavy. Now, on the other hand, you have Mr. Johnson. This young man that you heard in the evidence is a young man, aspiring rapper, wanted to make it as a rap artist. When you're going back through these exhibits, you're going to see a picture of him in front of the house on Bradley, engaged in a music video, right, for his rap. Hat kicked to the side, kind of grin on his face, because that's what he wanted to do. And his fate is directly in your hands. And like we talked about, it's never justice to wrongfully convict someone. And so that determination that you're going to make, beyond a reasonable doubt, is the heaviest one, maybe one of the heaviest decisions you'll ever make. And you've had an opportunity to sit through the trial and hear the evidence, observe the witnesses, and you've been told, keep an open mind. And I hope you have. I'm sure you have. And not to talk about the case. The thing that you've been listening to for days with people all around you that are going through the same thing, and then you have to be around them even when you're not here, and you can't talk about the elephant in the room. But today that changes. And not only are you allowed to talk about it, the judge has instructed you that you have to talk about it. And to engage in deliberations meaningfully, to listen to one another, to review the evidence that you've heard, to talk about it, and render a decision. But to the degree you're working together, what you never have to do is abandon your conscience. Now, I don't mean conscience like Cornelius Smith, that conscience, right? Because I don't think he really meant that when you heard from him. He said, oh, the reason I decided to tell the truth is I got a conscience. And we all know that's not the type of thing you're dealing with. You take that more seriously. You mean it. He didn't. You've heard a lot of concepts, the terms of art and the law, the burden of proof, presumption of innocence. And when we started this, I told you, Mr. Johnson sits before you innocent. And I'm again telling you today, after the state has closed its proof, he remains that way. He didn't kill Adolph Horton Jr. He didn't conspire to kill Adolph Horton Jr. And he wasn't the man holding the pistol in the Makita video. And it's going to be up to you to decide that. To watch those videos. Watch them closely. They want to talk about those videos, and I'm encouraging you to study them. Give them a close look. The state doesn't want to acknowledge what I told you in opening, and that is similar. It doesn't mean the same. Plenty of people have gray sweatpants, black shoes with white soles, black hoodies. And as we learned through the proof, in Memphis especially, and elsewhere, Bass Pro has. You can look at it, if we had a window, you could look at it and you could see the Bass Pro, which is the pyramid here. You also heard testimony about it being a fad at that point in time. Famous rappers wearing it. Other famous artists. I think I mentioned Gwen Stefani wearing Bass Pro. One rapper has a signature Bass Pro hat. You heard from one of the detectives that they even interviewed someone who gave them a potential suspect that wasn't Mr. Johnson and said that person always wore a Bass Pro hat. And you have to consider that. And then you have Sergeant Dabney, who, for the first time, I think he acknowledged this, sitting on the stand and says, I think those underwear are the same. They're both blue. You look at the underwear from Tulane Apartments, you look back.
Underwear?
The video, those are the same underwear.
Yikes.
Look at it. Look at the steel shots. And for yourself, determine, can you tell if those are the same? And as jurors, you get to make that call. You get to look at it for yourself and compare those. We've heard a lot about it's not 1981 anymore. And I agree, right? We've got cameras, but like I told you in opening, what also has advanced tremendously since 1981 is the world of forensics, right? Fingerprints, DNA, touch DNA. And you have to ask yourself, why is Justin Johnson's DNA nowhere in that car? There's DNA in that car. You heard a lot about they wiped it. Cornelius Smith said he wiped it. And we'll get to whether you believe that or not in a minute, okay? But he says he wiped it. But he didn't. There's fingerprints on it. Kristen Garner's, Trayon Ingram's, and Cornelius Smith. There was DNA found. One of it coming back to Trayon Ingram, right? Not Justin Johnson. Now, there's a lot of talk about gloves, right? They made a big point to say, you see gloves in the video. Now, they want you to believe that Mr. Johnson's running around in his Mercedes, and the reason that his prints aren't on it are because he's wearing gloves. And mind you, Cornelius Smith, when he said he wiped the car, never said he wiped the driver's side of the car. Okay? If you believe that. And they want you to believe Mr. Johnson's driving around this white Mercedes, including with his daughter. Look at those videos. You think, he's not wearing gloves. And he's got a little girl in tow that would presumably be in that car with him. No DNA recovered. None. Now, during proof, it was interesting because they would show the Mercedes go into crosstown and the Mercedes leave crosstown, and they would show a video of Mr. Johnson getting out and walking in the building or walking out of the building. There is no video that shows Mr. Johnson in that Mercedes. And you heard they had a reel, right? The video was a reel when they're doing crosstown. And when I asked it, I think it was Detective or Sergeant Dabney about there was surely other cars going in and out at this very time. And he said, yeah. But you have to ask yourself, was Justin Johnson ever in that Mercedes? So let's go to Kristen Gardner. Kristen Gardner gets up here and tries to tell you that. He tries to say he didn't know the car was stolen. Trayon was driving around in the car. And at first, he acts like, even under questioning from Mr. Hagerman, that he wasn't even present when the car was exchanged, because he tries to say, well, Trayon told me. And if you recall, Mr. Hagerman had to kind of go back at him. I think he said something like, I can't tell you that. And then he eventually started answering some questions. You also remember that this is the same guy that went into law enforcement and said, I've never been in that car. I don't know a guy named Justin Johnson other than on Instagram. He's a rapper. And then suddenly he starts evolving through the story. Still lying to law enforcement. He even looks at a video of himself, right, pumping gas and goes, that's not me in the video. And he's like, okay, it's me. But they're trying to tell you Justin Johnson's at the Valero gas station, right, when he's pumping gas. Where is he? Now, they want you to believe that this shadowy figure up in the right, top corner was Justin Johnson. And that he was the other passenger in the Infiniti, but you can't really make out who he is. You have to rely on Kristen Gardner. That's what you have to rely on. And we talked a little bit about, proof beyond a reasonable doubt. And I said one of the ways that you could use to kind of understand it is proof so convincing that you would not hesitate to rely upon it in making the most important decisions of your life. And it's really simple, right? You look there and you go, would I trust Kristen Gardner with anything? If he told me something, would I believe it? The answer is no. Because the more he talked, right, the more you realize he and Trayon are in the Mercedes. They're driving around with a Draco rifle, assault rifle, the same one described as being held by Cornelius Smith in the shooting of Adolph Ford Jr. Their prints are in the car. He says they have, he said, a ton of guns in that car. And then he starts talking about how he's related to Dolph, and they were trying to dump the car before, right? And he's reaching out to Dolph's people to try to get rid of a car, which is the reason why after this happened, immediately, day after, he's calling Trayon going, my name's in this. My name's in this. Why would his name be in it? And B, why couldn't he just like, I don't have anything to do with this? And at Valero, you do see Trayon and Kristen. They're there front and center. Now, there's been a lot of talk about the phone and location. And in the state's argument just now, you heard her saying what the expert said, a phone using, a tower that could be in, and he said could be, he said was in the service area of the Valero gas station, or then he said, I didn't do any drive testing, so I can't say what the coverage area would have been, right? And when you're looking at his slides, you've got that really thick PowerPoint exhibit, you'll be able to look at it. And you notice, right, that you're going to notice that the pictures are all really small, they're really zoomed in on the map. And he's talking about, like, this, do you think this is thorough? This is thorough. I mean, he's going through all these calls. Look at what he's doing. I mean, like, but then you have to ask yourself, well, what happens if you expand the map? And then you realize, and this is the exhibit I entered, you realize he's not even counting all the data and calls, because when you show what he left out at 12:23, right, at the time, immediately after A.L. Thornton Jr. was shot, there are several towers that Mr. Johnson's phone gets off of that are, one's 3 miles away in one direction, the other one is 3.2 miles away down by the Memphis airport. And then he has to go, I left those out. Not a really good explanation for why, right? Important. When there are a group of fine people that are looking to find the truth and have to make the decision and need to evaluate the accuracy of what he's telling you. And then you realize that when you talk about coverage areas and where things are in relation to these phones, somebody could be anywhere in a 3 mile radius, either any direction. And then you have to go, what is it? What does it show us? How did that help? How does that make you any more certain of someone's presumed location at a given point in time? Because he said it's not an exact science, and I'm not here to tell you that I can pinpoint where he is. And I didn't do drive testing, and I don't know. The next available tower is what a cell phone normally would look for, but also I can't even tell you if the towers were down at the time. That could make a difference. That could put you further out. I couldn't tell you if they were down for maintenance, if they were overburdened. And he said, look, if the tower's real busy, it'll direct you to the next tower. But what it doesn't establish is that Justin Johnson was involved in the conspiracy to kill Adolph Thornton. It doesn't establish that he killed Adolph Thornton or possessed a firearm. Now, a little bit about conspiracy and some more of the facts as you heard from some of the other witnesses. Now, I have to take a little bit of an issue with the state on something that was said during their initial argument. And that is this. There was no evidence at all that Justin Johnson was present for any meetings discussing this hit. What Cornelius Smith said was he met with Hernandez Govan and Juk, and Justin Johnson was not there. And then he said he met with Hernandez Govan and others on another occasion to discuss it, and Justin Johnson was not there. So to suggest that he was present and agreed, where's the agreement? He wasn't there. Now, you get to Mr. Smith. The court has already instructed you about accomplice testimony and is already warning you that when you're considering that, you have to use caution. Now, you also have to apply the credibility factors that are in the jury instructions, but they're not an exhaustive list, right? Like we talked about in voir dire. Some of you, most of you, probably all of you have had to talk to somebody before and go, are they telling me the truth or not? And that's exactly what's here. But accomplice testimony is flagged because that person may have an interest in the outcome of this case. And you go, what is that interest? Well, Cornelius Smith, number one, told him. He had to admit, he didn't want to admit it, but he's meeting with the state. He's hoping to get a benefit on his own sentence. He's supposed to be telling the truth. But he's writing to his sisters at the exact same time that he's meeting with the government, or the state rather, and telling them, I didn't do this, I'm just lying to get the deal. I'm just lying to get the deal. Now, is that his conscience, like he wanted to say? No. That's him telling his family. Why would he lie to his sisters? If he had a conscience, right? If he had done this out of the sense of, I did this awful thing, I feel awful, I've got to accept responsibility and tell the truth. No. But you remember, and it was kind of an interesting moment when he was testifying, because at one point he says, oh, that's not lying, I was gaming. Gaming's not lying. And the unfortunate part of all this is he's gaming everybody, including trying to game y'all. That's the problem. And he thinks he's going to walk. I mean, and the only person in this case who got paid for this. Remember, there is no proof whatsoever that Justin Johnson got a penny. Cornelia Smith got 50 grand for a lawyer for killing Adolph Thornton and didn't have to give it back. He didn't have to give it back. His lawyer was in the courtroom. And I asked him, I said, you remember, I said, how could you? You didn't give it back, you grew a conscience. What's going on with you? And he went, well, I did it. Services rendered, right? And the lawyer, he's talking about with his sisters, he's saying, oh, well, my lawyer's telling me to cooperate. I'm walking. I'm not doing it unless I can walk. Now, he was asked by Mr. Hagerman, have I ever told you you're not going to go to prison? And he said, no, you haven't. But you have to keep in mind two things, right? At the time he was giving all this information, they made him valuable to come in here and talk. He thought he was getting out. That's when those letters are going out. Those letters are going out, and he thinks he's getting out because he's got the lawyer, they got the cooperator from Ali Bobo to walk. And that's the type of thing you have to remember when you're assessing whether you can rely upon Cornelia Smith and anything that he said. The guy that sat in that chair, and he was asked by Mr. Hagerman, when you killed Adolph Thornton, what did you feel? And like it was nothing, said, I didn't feel anything. Let's try to get paid. And that's the guy that they want to put in front of you and say, believe it. You know, he went and talked about exchanging money, right? Getting $800, right? At one point said, do you find people that he got that Mr. Johnson somehow came back into town and he talked on the phone with him and brought $500. And then some other time, some other guy in a Chrysler 300 showed up and provided money to his girlfriend. Well, two things. One, that's not what Mr. Smith originally said to law enforcement. He said that Chrysler 300 came twice, and then Mr. Justin Johnson wasn't anywhere inside. Well, and what do you know about the Chrysler 300? Jamarcus Johnson, right? Did Jamarcus Johnson say when he was here in front of you, did you ever hear the state ask him, did you deliver the money? As part of you being involved in helping Mr. Johnson, did you deliver money for him? I mean, he asked about the email, or the text rather, about Cornelius emailing Justin's phone and saying, essentially, I need money for the birthday party. That's because Cornelius Smith is lying from start to finish. And then for the first time ever, here in court, he says he wiped the card out. Who's in contact? Who's in contact with Govan? According to Mr. Smith. Mr. Smith. Who's not in contact with Govan? Mr. Johnson. Did you hear anything about that? Now, when you go back in the jury room, you're going to be reviewing, obviously, these videos. And one of the things that you have to kind of ask yourself is timing. When you see Mr. Johnson in the elevator with his little girl leaving Crosstown that morning. And of course, you know there's going to be one exhibit that's the reel where the state had on it 11:51 in the morning. And then, of course, Mr. Hagerman came in, acknowledged the mistake to say that wasn't the right time, and put an officer on the stand, the lieutenant, to talk about getting access to the time, how he got the time sequence. But what that shows you is this. They don't know what time it was that day on that video. They don't know. I mean, mistakes get made. I'm not here to suggest that they don't. But you have to ask yourself, okay, the mistake got made, and then there's a timestamp. Okay, we want to put the timestamp in. And Seems like a logical choice, but then you have to listen to the lieutenant, right? And go, Lieutenant, what did you do to check and confirm that these were accurate times? Well, I looked at the live feed when I was in there. Had to have a technician, it's a computer. I don't understand it, but when I was there, I looked up at the screen and it appeared to be the right date and time. But not one person, you didn't hear from anybody that could say, that was confirmed, that's accurate, nothing happened with the system beforehand. And you even heard him say, it is not uncommon at all to pull surveillance cameras that have inaccurate date and times. Because you have to ask yourself about timing. You have to ask yourself about timing of leaving Crosstown, Mr. Johnson presumably going all the way to Whitehaven, if he's in that Mercedes and dropping his daughter off, right? And he said 20 minutes, something like that. Then he's supposedly driving all the way back to Wild Rose, 20 minutes, thereabouts, to pick up Cornelius Smith. They got to leave, then turn around and go to Bradley and go back to the white truck, right? And then get out and be in front of the Makita Cookie at 12:21. Now, that part of common sense and your everyday experiences, what does that tell you about going one place to the other, right? Take longer, right? If you're stopping places, if you have a park, if you're presumably dropping a child off, there's going to be some kind of an exchange of a child, maybe a discussion with a person, and you build all that in. That's a lot of time. And I would submit to you that one of the reasons that became an issue is about correcting that time is when the state realized that I was asking questions of that witness and asking him how long it would take to get from point A to point B to here to here to here. Because when you do the math and it's 11:51, it doesn't work. It doesn't work. And all this about Bradley, even the exchange of the Mercedes for the Infiniti, the dropping of the Mercedes at Bradley and picking up the SUV, whether somebody cleaned the Mercedes or didn't, who moved their Mercedes to the backyard, all of that, according to Cornelius Smith, should have been captured on Hernandez Govan's home security system, right? He said Govan had a security system directly facing Bradley because that's why when he decided that he was going to go wipe the car down, either the day it happened or the day after, he couldn't quite remember, he texted Govan and said he was coming through there because he didn't want Govan to mistake him for somebody trying to come up on him. I asked Detective or Sergeant Dabney, did y'all canvass? Yes, we canvassed the neighborhood. He didn't do it personally, but he would have presumed they would have talked to everybody, including Hernandez Govan. Right? We don't necessarily know if they did or didn't, because we didn't get to hear from Mr. Govan. I asked Detective Browning if he was aware of any video from there. No. But if Cornelius Smith, right, is this person that's telling you the truth, because the truth doesn't change, then the fact that there were videos would have been known as early as March of 22, when he was meeting with law enforcement. And I'm not saying law enforcement doesn't want to find out who did this. They would have absolutely went and looked. But we don't know. We don't know. And there's a lot that you should know that you don't. Because there's a material witness that should have been called, by the state that wasn't called. Hernandez Govan. And maybe some of you sat through this and thought, I want to hear what he has to say. And when I told you in the opening statement, I said, it's important, right, for you to weigh out and be able, as part of your duty as jurors, to be able to compare those two testimonies together. I'm sure some of you were thinking, yeah, that would make sense. I know we talked about that in Board IR, about getting two people to talk to kind of differentiate. Some of you that might have been a teacher talking about that is one of the ways that you try to figure out who's telling the truth, who isn't. But you weren't able to do that. You weren't able to do that. You were deprived of that. And to be clear, as you heard about Hernandez Govan, he was cooperating in this investigation. He met with law enforcement on at least 2 occasions pursuant to a proffer agreement, which meant he was allowed to go in and give information and not have his words used against him later. I don't have the ability to make good on a proffer letter. Only the state does. I don't have the ability to wave a magic wand and give him a reduced sentence if he comes in and testifies for me. So he's to my exclusion. He's to Mr. Johnson's exclusion, and ultimately to your exclusion. And if this is a truth-seeking function, why didn't the state call him? And it is. Your job is to find the truth of the matter. And ultimately to go, did they prove their case or not? But you were deprived of that. And the judge instructed you about a jury instruction. And that's the law. That's part of all the different things she told you. This is as important as anyhow. And the law states that it creates an inference that the testimony of that witness, Govan, would have been unfavorable to the state. Now, it's up to you to decide whether or not he was unavailable, a material witness, and whether or not there should be the inference. But you're allowed to make that inference in here. And unfavorable, I would tell you, unfavorable to the state means favorable to Mr. Johnson. And knowing that, can you really render a verdict of guilty and have your mind rest easy? And not walk away and go, I just don't know if I did the right thing.
It's too long.
Knowing that there was information out there that could have been presented to you and wasn't. That would have been favorable to Mr. Johnson. That I couldn't give you. Can you be morally certain in that instance? In order to be convinced beyond a reasonable doubt that Mr. Johnson is the one in that Nikita video, you have to consider everything. You have to consider what you heard. And you have to go, what I heard from Kristen Garner and Cornelius Smith, was that so convincing that I wouldn't hesitate to rely upon it in making those most important decisions in your own life? Will my mind rest easy if I convict this young man based on their word in conjunction with that video and the other videos and what you didn't hear? The answer is no. When you examine your conscience after you've taken the time to deliberate, I think you'll find the answer is no. Two things I want you to remember, and I'm wrapping up. The way the burden of proof works. You've heard the statement, right? We ain't got nothing to prove. You may say that to somebody. I ain't got nothing to prove here. Justin Johnson, he doesn't have anything to prove here. And we've all heard the term benefit of the doubt. Right? Everybody likes to give somebody the benefit of the doubt. You are legally prohibited from giving the state the benefit of the doubt. You can't carry their water for them. Again, I appreciate it. This is, as I said, the last time I get to speak to you. The state's going to get one more opportunity to talk to you this morning. They get the last word. That's how the system's set up. But it has been my honor to represent Mr. Johnson in this case. It's been my honor to present this case before you all. And thank you so much.
Thank you, sir.
Yo, he did that without any notes, though. You got to give him a little bit of credit for that. All right, here's the last guy.
We started this with a little Memphis talk. Those cookies are fire. That's how we started it. A little more Memphis talk. What y'all even talking about? What y'all even talking about? A missing witness? Hernandez Govan? A missing witness? Hernandez Govan? Absent material witness. And the defense wants to say that is Hernandez Govan? What do we know about Hernandez Govan? He's a defendant in the case. He is charged with murder and conspiracy to murder, whether it's from television or whether it's in black and white at the bottom of that same instruction. A defendant has the right not to testify and incriminate himself. He is a defendant. He is not a missing witness. That would be insane. I could willy-nilly just start calling every defendant. And they just have to come in here, that's fine. That's crazy. It doesn't even work like that on television. It doesn't even work like that in black and white in front of you. That would be insanity, and that wouldn't be a legal system where you had a Fifth Amendment right. That would be an inquisition, actually what they used to call it, where you didn't have that right not to come to court. So the idea that the defense would call a defendant who's charged with this crime an absent witness shows you how desperate it is. And then we'll talk about things in isolation. Look at Kirsten Gardner. I'm sure he knew that car was stolen. I'm sure he did too. Well, then how can you believe him? Or look at Cornelius Smith. I'm sure it's not his conscience that made him talk. I'm sure it's not either. He talked because he's caught. So don't believe him. So I made a mistake on one slide about the time, so it was corrected. So we can't believe video. You know, there's a word that actually exists because it's a thing. It's corroboration. It's corroboration is what they call it. Like, can you look at something somebody's saying and compare it to something else and then determine whether or not that person's telling the truth about it? You know, that's how we should judge stuff. Did Kirsten Gardner know the car was stolen? I bet he did. Does he think Treon Ingram actually paid for it because of something? No, we didn't pay for the car. They're riding around with guns in a stolen car and they're trading it with their buddy, Mr. Johnson. But how do we know that? Corroboration. Is there evidence that shows us that? Well, there's the Valero video, which shows something strange. Shows something strange. Shows Kirsten come up in the car and somebody else get in and drive off. Strange. Another little piece of corroboration. Where's Justin Johnson's phone at the time? Well, in the area of the Valero station. Can you say it's in the parking lot? No, you can't. But it's in the Valero, in the vicinity of the Valero station. Oh my God, is there something else? Yeah. And this is what is ignored throughout the entire talk we just heard. We don't just have towers. We just don't have cell phone towers. We don't just have a Valero video. We just don't have a Haven Court video. We don't just have a crosstown video. We don't just have a defendant who's like, Cornelius Smith, I'm guilty, and so is he. That's supposed to in the parking lot shooting him. We got Justin Johnson's actual phone. We got his actual phone. In this case, it's been over so many times. Things that happen that are actually really dramatic just sort of happen. Because as soon as we saw the video of the Makeda shooting, and as soon as you see the video of Crosstown with him leaving in the exact same outfit in the white Mercedes, case is over. But we keep going. As soon as you hear from a co-defendant who's like, that's me in the parking lot shooting Dolph, I'm going to prison, and Justin Johnson's the guy next to me doing it, case is over. As soon as you see the Haven Court video, 40 minutes after the shooting of the two shooters and his cousin, case is over. But then things kept on happening. That if you didn't have all that proof, would have even been more dramatic, or would have been dramatic. When they happened, I would see in your eyes a little thing, a little twinkle. We have his phone. And the night before, we had a text. The night before the homicide, we had a text. From who? Treon Ingram. To who? Justin Johnson. Sending him what? A picture of the white Mercedes. What do we have next? Another text. Justin Johnson. Treon Ingram. Dropping his location. Bradley. Kirsten said they met on Bradley. Then they drove to Valero. And they switched cars. That's corroboration. So do you have to be willing to trust Kirsten Gardner with the keys to your car? Of course not. You think I trust Kirsten Gardner with the keys to my car? But do I know he's telling the truth about this? Well, yeah, I do. Because it's on video at Valero. It's documented in his phone with literal pictures and locations. This is plain and simple. Do I have to believe that Cornelius Smith is talking because of pangs of conscience? Now, he's talking because he got a call. Is he hoping that the truth will help him? Absolutely. He's hoping that the truth will help him. Is he going to prison after this? Absolutely. He's going to prison after this. Is there anything about his testimony, like kissing ours, that we can corroborate? Oh my goodness. What's the first thing he tells us about that day? Justin Johnson calls me. I think I missed a call, and then I get a second one. And what do we got? Justin Johnson's phone. You can delete your call logs, which he did from that day, but they're still in the phone. And what do you know? 2 calls to Cornelius Smith from him right before he comes and picks him up at Lamar and Sons. That's corroboration. What does Smith tell us? We go to Bradley directly after the shooting, but dump the cars. Dump the cars is important because here's another little, like, real tricky truth test. Justin's driving the white Mercedes. You see the video, of course, where he testifies to it. He says, we drive to Bradley. He hands me the keys to the Expedition. I jump out of the car. I get in the Expedition driving while Justin parks the car in the driveway or there on the front. Well, we know the white Expedition is also Justin's car. They're saying it across town with her testimony. What do we see at Haven Court? Cornelius says, from there we end up going to Justin's cousin's apartment. It used to be called the 2 Lanes, Gospel Gardens, the address on Haven Court. We see the white Expedition arrive. And who's driving? The white Expedition. Justin's car. Who's driving? The dude with the messed up shoulder and the messed up shirt. Cornelius Smith. I mean, how do you make that up? How do you make that up? They pull up at Haven Court with Cornelius Smith driving and Justin in the passenger seat, just like it had to happen, just like Cornelius Smith told you when he testified. We do the shooting. Justin's driving the white Mercedes. He hands me the keys to the Expedition. We get to Bradley. I jump out. I get in the driver's seat of the Expedition. Justin parks the Mercedes, jumps in, Haven Court. And what do you know? That's what we see. And what do you know? If you're lying, that detail is almost impossible to account for. Corroboration. We plainly see in the video, Haven Court. We plainly see them go inside. We plainly see Justin Johnson come out, meet this character in the Dodge Challenger, get some other clothes, get some bags, go in. We plainly see the Chevy Trax come, Angela Arnold, pick up Cornelius. We plainly see Justin get in his car, the Expedition, and the 2 pull out. His testimony is corroborated over and over and over. And that's so incredibly important as we do trials. That's how we make decisions. Corroboration. That's why we have evidence. That's why we don't just call one witness and say it's over with. We put evidence in front of you. And one of those moments when this trial was just over again for the 5th time was when we were showing the slide from his phone, from Justin's phone. Cornelius says right after the shooting, Justin calls and FaceTimes with somebody. He says it's a big joke. The guy that put the money down for this. Number 2 is CMG. Guy that put hits on the other artists too. Cornelius says it's a FaceTime. Spelling out golf with your hands. what do we find at Justin's side? I mean, delete the stuff all day long. He did. Whole day, November 17th. Deleted all day long, but it's still in there. A call and FaceTime interaction with him. Justin Johnson with Big Joe. With Big Joe. Cornelius tells you. And there you see it in black and white. It's not 1981. That's true. Called on camera and everything else, but you're also walking around your pocket with a phone that you can delete a call on, but it's still there. The times you called Cornelius Smith that morning, still there. The time when you called and then FaceTime with Big Joe right after the murder of Dolph, still there. The videos from Haven Court that show you arriving, still there. The videos of Haven Court that see you changing clothes. Did he have enough time to do it? Yeah, he had enough time to do it. He left crossing at 10:51. He had over an hour and a half to go drop off his kid 20 minutes away and drive 10 minutes. Total trip probably take you 30 or 40 minutes. Yeah, you have enough time to do it. We saw him do it. Memphis Talk, all the times. All the times. Before the murder, we see him at Crosstown in the murder outfit. Similar clothing? No. Identical clothing. Patch on the legs, Bass Pro hat, everything. Before the murder, the Mercedes. Similar Mercedes? No. Back end damage, just like we saw in the video. During the murder, again, caught on video, white Mercedes, back end damage, the exact same clothing across town. Looks like him. Right-handed like him. Gloved up, like Cornelius said. Driving away from the murder. Who you calling? Who you texting? Big Joe. Caught before. Caught during. And then caught after. At Haven Court. Video of them arriving and leaving. Caught before, during, and after. That's called being caught all the times. All the times. He is literally caught before, during, and after. Caught all the times. And then what does he do? Then what do we know? Another Memphis phrase. Get on down. Get on down. Cross town, the last video. Packing my suitcases to head out of town. Packing my suitcases to head out of town and get on down. Like the police tell us, a manhunt. Not just in Memphis, well beyond Memphis. As Jamarcus tells us, he's going in and out of town. As Jamarcus tells us, he sees pictures on social media, Rolls Royce, stacks of money. Get out of town, get on down. The crime has been committed, Dolph has been killed, and we literally see him at the elevator with his suitcases getting on down. Flight can create an inference of guilt. Well, yeah. This case was over when you saw the videos. This case was over when you heard from the co-defendant. This case was over when you saw him at Crosstown with the suitcases leaving. knowing that the manhunt was coming and he was out of town and leaving. Really. Really. Now it's time for us to get on down, but we don't get on down by fleeing. We don't get on down by hiding. We don't get on down with pictures of Rolls Royces, stacks of money. We get on down by doing what's right and doing our jobs and looking at the evidence, the witnesses, the corroboration, and applying the law to those things. We get on down by doing justice. We get on down by saying you are called all the times. You are called all the times and you're guilty of all the things. Conspiracy to commit murder. I just heard, okay, let's at least cut him a break on the conspiracy to commit murder because man, he wasn't there for at least like one of these meetings with Big Jook or something. That's what I just heard. Let's cut him a little break on the conspiracy to murder because he's not at this meeting with, Big Jook and Govan and Cornelius. So let's cut him a little break on that. That's what I heard. Let's cut him a little break on that. There's no requirement in the law that every conspirator have to be at every single meeting with each other. There has to be an agreement and an understanding. And there was clearly an understanding. Big Jook is going to pay money to take out PRE artists, and at the top of that chain is Dolph. Now, does he demonstrate any understanding of that? Is there anything he does that shows he's part of this understanding that this is going to happen? Yeah. He literally shows up with gloves and guns, has a white Mercedes he gets from Treon, has Cornelius driving next to him, and they drive and go do it. So the idea that, okay, he committed the murder, we give him a break and leave, no. He's guilty of the conspiracy just like they're all guilty of the conspiracy. And of course he's guilty of the murder because we watched it on video. Last short thing. Just one lyric. You too real. Dolph, you too real. He rapped about what he calls come up. What he saw in neighborhoods, what he saw in his family, growing up. Too real. He rapped about people that he had a rivalry with. Too real. Dolph, too real. Included disses of dangerous people like Big Jook. You're too real. Too real. Too real. Last moments of his life, last seconds of his life. How long was the videotape? 30 seconds. You're too real. Dies on the floor in a neighborhood cookie store in Orangeville. You're too real. Your family misses you. Erica Mia, the kids. You too real. This is real. This is too real. And when the killer, 1 to 2, is caught on video, all the times, we even watch him get on down, it's time for us to be real. And we don't need Memphis talk for that. It's called
He going too long.
just do what's right.
He going too long. Let's go.
It's as simple as that. Just do what's right. Cornelius Smith and Justin Johnson killed Adolph Thornton Jr. November 17th. We watched it happen. Cornelius Smith, Justin Johnson, Hernandez Govan, Big Jud, they all conspired to have it done, and it was done. November 17th, 2021. And as he did it, he was already a convicted felon. He should be found guilty of all counts. We do what's right. That's how we do. Guilty conspiracy to commit murder, murder in the first degree, and convicted felon in possession of a handgun.
Woo.
Ladies and gentlemen,
All right.
a few more pages of the charge to read to you. I'm gonna
Okay, so
go
the
on page 29.
all right, so the judge has got some more to read to them. I'm sorry, this is taking way longer than I thought it
Go on
would.
page 29.
What did you say? Can y'all get that? What's that kitchen look like? What's that kitchen look like? The kitchen needs to look right. Okay, good. Call me when y'all get the kitchen looking right. And you can't wear pajamas outside.
Verdict. Count
All right.
one.
So, all right. So you're gonna go with not guilty, Mo? Okay. Okay. All right. Let me add that to the chat as well. Let me add what do you think is the verdict going to be based upon the closing arguments? Based upon the closing arguments, what do you think what is the verdict going to be? And I understand you may not be familiar with the whole case. I am going to pull up a video that kind of explains it, but they were going through it and I was like, oh man, let's do it real quick. So I do understand that you're making this case without full knowledge of everything. What do we got? Guilty, not guilty. Let's go with hung jury. Let's add hung jury to this. All right, let's dance. All right. Okay, new poll is up in there. Thank y'all so much for stopping by today. I just wanted to go through this one because one, I was thinking it was going to go longer than that when I looked up this morning and said, wait, they're going to closing arguments today, realizing that this case has been going on for a week. So it's a murder trial. It has some hints of RICO. We're going to talk about those in a moment as well. It has some hints of RICO, not really truly RICO in the whole sense that we're familiar with or that we want to talk about. I know Mo Justice is in here, so she'll definitely be chiming in as well. I wanted to just go over this because I thought it was really interesting. I thought it was quick and to the point. The judge got in, read the instructions. They took about 20 minutes. The first prosecutor gave her closing arguments. It took about 20 minutes. Defense gave his closing arguments. And then the secondary prosecutor gave his closing arguments. They were a little long, but I can understand what they're trying to do. And so I thought it was interesting. I just want to jump in and talk about it today. What do we have here? Okay, thank you so much. Gene was checking out Black Law Students, what's it called? Spaces, Twitter Spaces last night. Thank you so much for hanging out with us on last night. That was a lot of fun. What does Mo Justice say? She says the judge yesterday drafted all new charges. Okay, I don't know what the original charges were. So if they did, they just hit him up with new charges that they weren't defending against. I don't know. Um, the male prosecutor is a beast. Okay. Well, we're going to see what happens. We're going to see how long it takes the jury to come back with a decision, which I think should be interesting. Now, I am going to, we'll definitely be reporting back this week or whenever this comes up. Man, I got a lot of things I want to talk about. I got stuff going on with young Dolph. I got stuff talking about this trial. I got all this kind of stuff like that. All this craziness. Lots of it. Lots of hey, there's a lot of stuff going on that's not YSL, believe it or not. All right. So let me here. I'm gonna do this. I am gonna bring this one in. I told you I like people kind of explaining these, whether it be street level dudes or whatnot that explain cases. I think that's such an interesting genre. So I got a quick one.
First couple of days of the Young Dolph.
All right. I thought this was a good one to kind of explain the Young Dolph case, just in case you're not up to speed on it. So let me drop this out of the way. Thank you, by the way. By the way, thank you so very much. I apologize for the super chat. Cull Obsidian says, enjoy enjoy your YSL free day. Thank you so much for that. Blessing the team with the $10 super. Thank you so much for that. All right. So if you're not familiar with the Young Dolph case, I thought this young man did a pretty good job of explaining it and putting it into context so that everybody could understand it. Pretty straightforward, pretty clean language, all that kind of stuff like that. So I like to support content creators that do good content like that. So hopefully this will bring everybody at least in the zip code of up to speed. You ain't got to be doing 100 miles per hour, but at least, 75. Get you up to 75 at least. Let's see how we do. And let's bring them in. This is a Poetic Flacco. Let's go. Let's go.
The first couple of days of the Young Dolph trial has made it abundantly clear that the writing is on the wall for Mr. Peanut Head, aka Yo Gotti. The entire first and second day of trial is the prosecution showing up to court and making it 100% clear, even for the slow people in the back, that Young Dolph was taken off this earth due to the beef with Yo Gotti and CMG, and that CMG paid for the hit, orchestrated the hit, and that CMG is the sole reason why Young Dolph is currently deceased. Y'all just heard me say that, and y'all are probably thinking that's the most anticlimactic thing ever, because we all knew this the day Young Dolph passed away, that Yo Gotti and CMG was involved. Just by looking at the three dudes who was arrested for the murder of Young Dolph, a fifth grader with a double-digit IQ could very easily trace this back to Yo Gotti and CMG. Hernandez Govain is the right-hand man to Yo Gotti's brother, Big Jook. So it's not hard to see how Hernandez Govain, who's being accused of masterminding this and setting it up and recruiting Straight Drop and Cornelius, it's not hard to figure out that Hernandez Govain, who was the mastermind, probably got instructions from Yo Gotti and CMG, and he was the bag man. He was the point man. He was the one who did all the dirty work and recruited the shooters. That wasn't hard to figure out. I didn't need the police to tell me this. Nor do I think the prosecutors needed to include a theory of Yo Gotti and CMG to get a slam dunk conviction. They could have explored a theory of Straight Drop being a revenge-thirsty person because Young Dolph signed the person who killed one of his best friends, D-Money. That could have been a theory they could have explored, but I believe the prosecutors included this particular theory of CMG, Big Jook, and Yo Gotti being involved in Young Dolph death and paying for the hit, because this is gonna set up further litigations after this trial, and CMG is in trouble. But we're gonna discuss that later on in the video, and we're also gonna discuss a lot of mistakes that CMG, Big Jook, and Yo Gotti made that has landed them in this particular situation where they're being name dropped all throughout trial. Now, from the opening statements, the prosecutors were blaming Big Jook and CMG and Yo Gotti for the death of Young Dolph. They said that Young Dolph's death is directly related to the ongoing beef with CMG.
In this game, trying to make it on your own can create enemies. PRE, Paper Route Empire, his label, is not the only label in Memphis. He's not the only famous rapper in Memphis. Another label, CMG, Cocaine Music Group, and they became an enemy. They wanted Dolph under their label, but he turned down millions. I want to do it myself. The second time, they wanted Dolph under their label, but he turned down many millions. I want to do it myself.
They're laying it on thick right now. They're painting CMG as jealous, obsessed, insecure haters who wanted to see Young Dolph fail and get unalived and taken off this earth because he wouldn't sign to them and fall under their control. Now, I don't know if that framing of the story is fair or unfair to Yo Gotti or if it's correct, because, like, I'm sure, bruh, all right? Like, the story and the plot extends deeper than what we're being told at surface level. Because even though Yo Gotti does come across sometimes as, like, you know, sort of like monocolly, like emotionless, demonic, but I don't think that insecure, demonic peanut head bruh is out here unaliving folks just because they wouldn't sign to the label. Now, obviously, we know there was a back and forth, diss records, etc., but I'm sure the root point of this probably stems from Young Dolph not signing, but I think the real issues extends past that. Because if that's the case, bro, Yo Gotti will be out here just unaliving everyone who wouldn't sign to him.
And in this game, whether it's smart or not, there are things called, it's in Memphis, we call them diss tracks. D-I-S-S.
We got diss
Or
tracks
rap.
going on. Diss tracks are Rico now.
Where I may insult, level whatever sort of insults and everything else I want to in the song itself. And Dolph had plenty of those. And he had plenty of those directed at this other label, the Cocaine Music Group, at their artist, and at their number 2 person. His name is Big Jook, the number 2 person of Cocaine Music Group.
The prosecution is very slick and intentional with how they label things. They could have very easily said Big Jook, but they made sure to describe Big Jook as Yo Gotti's big brother. And they also made sure on repeatedly to describe Big Jook as second in command at CMG. And they said that over and over and over again to drill it in the heads of the public as well as the head of the jury that this isn't an isolated incident. This is Big Jook, second in command at CMG, putting the hit on Young Dolph in furtherance of CMG. This is a CMG and Young Dolph situation, which could be very problematic in the future for CMG. Now, the prosecution go on to say that Big Jook put $100,000 on Young Dolph's head.
Because Big Jook, person I told you about before, the number 2 guy at CMG, he's put out a hit. A hit. $100,000 to whoever kills Dolph.
They paint Big Jook and CMG as bloodthirsty haters who essentially just use 2 peons straight dropping Cornelius as clog in their system to take out Young Dolph. They're saying that Big Jook and CMG, they are the ultimate culprits, which if that's true, if that's the case, then why wasn't Big Jook included in this indictment? Because when Hernandez Govain was arrested, Marquette Hernandez Govain, when he was arrested, well, he was arrested because he was the one who orchestrated the hit. He was the one who got the money from Big Jook, got the orders from Big Jook, and found Cornelius and Straight Drop and had him go out to do the hit. So they knew Big Jook was involved when Big Jook was alive. So why was Big Jook never charged? Why? If this is them coming to court and both sides is agreeing, like this right here is the fact summary. These are the things that we all agree on, that Big Jook and them put the hit out on Young Dolph. Well, if that's the fact summary, then why wasn't Big Jook ever indicted? Cornelius Smith's testimony does a really great job at backing up the prosecutor's theory that Big Jook and CMG are the real culprit and that Cornelius and Straight Drop were just clogs in their system. That, you know, it could have been anybody. If it wasn't Cornelius and Straight Drop, it would have been two other peons dumb enough to take out Young Dolph at the instructions of Big Jook and CMG. Cornelius Smith's testimony at trial really helped the prosecutor's theory because Cornelius Smith took the stand and he firstly painted Big Jook and CMG as super bloodthirsty. Not only was there a hit out on Young Dolph, but Big Jook also instructed them to take out any PRE artist they see, and they will also get paid for that as well.
So how did you get to be with Justin Johnson this day on November 17th, 2021?
We knew that, you know, they had a hit on Dolph and them head or whatever, so.
Who had a hit on whose head?
Big Jook had a hit on Dolph head or whatnot, so.
How do you know that Big Jook had a hit on Dolph's head?
Cause Quick had told me about it, Quick, and, you know what I'm saying, being just
How much money was it supposed to be?
$100,000 on Dolph head.
And had you agreed to do this hit?
Yes, sir.
Had Justin agreed to do this hit?
Yes, sir.
Were y'all going to do it together?
Yeah, they been on it, but yeah.
Was there any arrangements as far as splitting the money or anything?
Yeah, me and him supposed to be giving Quick $10,000 apiece.
All right, so you and him were going to give Govan $10,000 apiece?
Yeah.
And how much were you going to get?
I was getting 40, he was getting 40.
Okay.
First off, these dudes are nincompoops, absolute idiots. Hernandez Govain is a part of Big Jook's team. He's a part of Big Jook's entourage. He's one of Big Jook's right-hand man. So why would you guys accept $100,000 to do the hit on Young Dolph and then turn around and give him $10K a piece for doing absolutely nothing? Like, it doesn't make sense at all. You're essentially giving $20,000 back to the people who put the hit on Young Dolph when you're supposed to be pocketing all that money. But keep that number in the back of your mind. $100,000. They're supposed to get $40,000 a piece, and Hernandez Govain, Big Jook's people, is supposed to get $20,000 for the hit on Young Dolph.
Had either you called him or he called you or anything like
He
this?
had called me the first time I missed the call. Then he called me back, I answered. He was telling me basically they were pulling up because we already knew what was going on.
When you say you already knew what was going on, you already knew what this is about?
Yeah, because we knew they were doing the turkey drive, so we was actually on our way to Westwood.
Had you and Justin talked about this particular day before?
Like, nah, not the specific day. Like, we just knew that it was turkey drive going every day that week.
Okay. You knew that, is it fair to say that you knew Dolph was involved in these turkey drives this week before Thanksgiving?
Yeah, we didn't know we were going to catch him, but we knew he did his artists. You know, everybody had a hit on their head. Everybody had a price on their heads.
From Jook?
Yeah, from Jook.
And that was going to be y'all's business this week?
Yeah, that was our beating deal.
So Big Jook not only put a hit out on Young Dolph, but he put a hit out on every artist signed to Young Dolph. This man was so bloodthirsty, bro, that it didn't matter who they killed. He just wanted people dead. Now, here's the thing, bro. Like, you think the feds are aware, or you think Memphis is aware that CMG, owned by Yo Gotti, is putting hits out on people and have open bounties on people, and they're just going to charge these two peons and then convict them and move on with their day is not gonna happen. Like that's not how that works. They're gonna double back after this case and get their taste of the blood on Yo Gotti and others.
Right.
That's just how these things work. I'm just being real, especially if you have somebody like Cornelius who's an open informant, who is down to take down Yo Gotti and CMG since Big Jook just passed away. But here's the first error they made. Now, I think Cornelius would have been snitched. Listen, yo, Cornelius don't strike me as the type of fool who would go down for a body while Yo Gotti and Big Jook lived their life merrily after. That's not how that works. So I think Cornelius would have snitched regardless. But they made a big mistake because he caught the body for you because he was the first one who hopped out with the Draco and dumped the young Dolph. But their biggest mistake they made was they decided, after putting out the $100,000 bounty that got answered, they decided they wasn't going to pay poor Cornelius. They was going to give him close to nothing for the hit on young Dolph.
Yeah, I got scared. I got on them.
Did y'all drive out there?
Yeah, we drove with them.
Stay in a hotel?
Yeah, stayed in the hotel.
About how long were you gone?
I was gone a couple days. I ain't had any more money on me. Ain't had any more money.
Run out of money, you gotta come back.
Yeah, I gotta come back.
And you come back, do you pick up that money from the old woman?
Yeah, I picked up the money from her, and I saw how much it was. I'm like, hell no. You know what I'm saying? Like, $500.
Hey, bro, y'all know y'all wrong, bro. Because Cornelius was a self-admitted smoker who had a bad drug habit, who was trying to get some money for his daughter's birthday as well as to support his drug habit. But y'all know y'all wrong, bro. Because even though he's a smoker, y'all don't got to treat the man like a smoker, bro. Yo, so after the hit happens, Big Jook apparently just cut off communications, and Hernandez Govain was paranoid. So now Cornelius, who was once working through Hernandez Govain and Big Jook, was now having to answer to somebody like 15 years his junior in straight drop, Justin Johnson, who apparently got some type of money. He got paid. He got some money. And, you know, when it came to breaking off the money to Cornelius Smith, bro, he gave him $500, bro, out of $100,000. What? But of course, he said, yo, that's the first payment. That's just the first payment. Maybe they came back and gave him the rest of his $40,000 on the second installment. Let's see how much he got his second installment.
You could spend that on pills in one day, I bet.
Yeah, it's over. Yeah, I can bet it.
What'd you do with the letter?
I flushed down the toilet at the hotel room.
All right. Is that the only time you got any money from Justin?
Nah, a couple days later, I was in the city or whatever, and he was saying that he was gonna have his folks pull up on me, bring me some money or whatever, hold me down. So I'm thinking he been pulled up about 20, 30,000 leave, you know what I'm saying? But I had my girl to get out the car, and she met the person that was driving on the street or whatever. I had her to have her face mask on, and she said they had their face masks on, so we don't know who it was, but they gave her $300.
$300.
Yeah.
Okay. And this is from Justin's folks.
Yeah, this from Justin folks.
All right. So now we've been paid about $800.
Yeah.
Is that right?
Yeah.
Is there any other payment coming?
Nah, all the payments stopped, man.
All the payments stopped.
Everything stopped.
Oh, y'all nasty. Yo, that's some nasty work, Straight Drop. Yo, Straight Drop took the $100,000, man, and spent it on Gucci North Face outfits while giving this man $800 for a potential life sentence in prison for a high-profile murder like the Young Dolph case. Yo, this is insane. Yeah, yo, and this is also like the perfect recipe to create a snitch. Even if Cornelius Smith was not a rat at heart, even if he was a virtuous street dude, which is, you know, that's a thing apparently, right? Even if he has some type of street morals and principles, yo, you just push that man to the corner, bruh. Where even if he ain't want to rat, he just had to rap for the culture, man, cause you played with him. Cause you played with him. You made him into a rat, which means, hey, listen, I'll be real, bro. Bro, like, you a rat too. And the funniest part about this, bro, is after they pushed that man back to the corner, gave him $800 for a high profile case like this, right? Their plans were, oh, we're never going to get caught and he's not going to come forward because, like, bro, if you come forward, you're going to jail. So their plan was they were never going to get caught. That's why they probably stiffed him out of the money, because they thought, okay, I mean, if you don't get caught, like, you're not going to, like, tell, right? Because, you know, you're not going to go to jail, right? You're not going to risk going to jail by coming forward and telling about how we stiffed you out of $100,000. But when they did get caught, now they want to ensure he don't tell. Check out the damage control that CMG, and Yo Gotti and Big Jook and them did, to try to get Cornelius not to snitch after stiffing him out of his $100,000.
Your case got $50,000 to represent you. Did he not?
I don't know exactly how much you get. I don't know. I
Okay.
can't say.
All right. And you knew that, just we're all clear here, that money came from CMG, right?
Yeah, I don't know exactly who, but yeah.
All right. So you talked today, you got paid for what you just testified to, didn't you?
After I was locked up,
You got paid,
my
right?
lawyer was paid. Lawyer.
You got $50,000 to pay a lawyer, right?
I didn't get it in my hand. Correct. I don't know how much it was, but correct, my lawyer.
Okay. And there's no question that that money was for services rendered. Killing Dolph.
Basically.
You took it, didn't you?
Yeah.
Did your conscience bother you?
Come on.
Your conscience.
After I came to my senses, yeah.
Did you say, I can't have that money? I can't use that money because you still got a lawyer here.
Nah, I ain't say that. I ain't say
You took
that.
the money.
Yeah, I took the money. I got the money.
There's so many levels to this that makes this absolutely insane. So Straight Drop Lawyer is the one who's cross-examining Cornelius. So Straight Drop Lawyer is telling Cornelius, yo, we know you got $50,000 for your lawyer. Ain't that right? So Straight Drop essentially snitched on CMG and told his lawyer, hey, he got $50,000. Ask him about that when he take the stand. So it's also insane that they didn't give him any money after the hit happened, but they're now going to implicate themselves by paying $50,000 for his lawyer after he get arrested, as if that's gonna save him from taking a stand and testifying. He could have used the 40 bands on the street when he had about a solid couple of months, right, for freedom. You feel me? Apparently he needed the money to pay for things for his daughter's birthday party. So he's already mad at you guys. He's already tight. And you think paying $50,000 towards his lawyer is going to do anything but implicate you guys in this young Dolph murder, because it's not going to stop him from telling and snitching. Which it didn't, because he's telling and snitching. This is absolutely insane. And if you guys think that CMG... Now, Big Jook is dead. So the next in command is, well, Yo Gotti. If you think the police is going to let CMG and Yo Gotti get away with documented putting $100K on Young Dolph's head, documented paying for the lawyer fee of one of Young Dolph's murderers, if you think the feds or the police, the state police, is gonna let them get away with this, bro, you're out of your mind. The writing is on the wall. The CMG RICO is coming. Absolutely, it's coming. Let me know in the comment section, what do you guys think about this, all right? And if you're still watching, man, click on this video right here, man, to find out about why
I thought
all
this
these
was a
clowns.
fun explanation of just the last 4 days. And again, because the case is over with now. I mean, it's been given to the jury. That's crazy. It was 4 days. This trial was 4 days. Now, granted, it's not a true RICO trial, a RICO case, in my opinion. It has a lot of the elements in it, but it's really just a murder trial. The Young Dolph case is a murder trial, but it has hints of, sprinkles of, dusting of RICO, which will be held, which will come up later on, of course, with this whole was it CMG music label. They're gonna catch it. They're gonna catch it for sure. You think you're in the wrong occupation? Why? Oh no, we don't need you. No, because we don't need you. Look, Gordon, we don't need you catching no RICO. We already getting RICO up in here in the best live chat on the planet. We don't need you. Look, we don't want to have to put up bail money for you. Let a guy use the little, here we go. I'm gonna use a 10 piece for your bail money. There we go. We don't want to do that, man. We do not want to do that to you. But I just thought this was super interesting, especially in light of what we were looking at in the YSL trial. I wanted to kind of hear the instructions from the judge and closing arguments from the prosecution as well as the defense. I thought they were pretty good considering the YSL one was an hour and a half for pretty much everybody. So you know good and well that this is going to be the closing arguments and final instructions is going to be at least 2 days, maybe even more. That's bananas. I see lots of good commentary back and forth. We got you, brother. We do not want you in jail, Gordon. We need you here in the best live chat. Because then otherwise you got to be on like the contraband phone in jail. And I don't know what, hey, look, we don't know how you got there, anything like that. It's going to be really weird. I don't want that. We don't need that for you. We don't need you on the RICO charges for sure. As Dream just said, we don't need the RICO. We don't need that. What's going on, Donna? Good to see you. Grace and peace, friend. So we've been talking about the young Dolph trial in Memphis, Tennessee. Is really interesting. If nothing else, it's a murder trial that got started and ended in a week, which is crazy. Now, I don't know how long the jury is going to take. Now, the jury might take, 2 months. I don't know. I doubt it. I doubt it's going to take that long. But the jury, let's just say the jury takes, today's Thursday, technically. So they could take all the rest of today and tomorrow and come back with a verdict tomorrow afternoon. That would be crazy. And then it could literally say a murder trial took place, a high profile murder trial started and ended in a week. That would be wild. So I thought that was super cool. I appreciate y'all so much for tapping in. I see lots of good people in the chat and all of those kind of good things. Now we got to talk about y'all. Look, I'm an equal opportunity offender. So I offend Georgia. I'm going to go a little bit north. I'm going to offend Memphis. But y'all, we got to go ahead and give New York that smoke. Y'all, New York, what are y'all doing? What is going on in New York? I just need to know what is happening in New York with mayor. I just can't believe that your mayor is now getting caught up in corruption. Let's bring this up. Let's go ahead and hear what's going on with Mayor Adams. Let's go.
Welcome back and Alive Now. I'm Austin Westfall. We continue to cover this breaking story out of New York City. We're learning tonight that New York City Mayor Eric Adams was indicted by a grand jury on criminal charges Wednesday evening following escalating federal criminal investigations against his administration, nearly a year after FBI agents seized his phones, according to multiple reports. We just got a statement in from Adams himself. I want to play this out.
My fellow New Yorkers, it is now my belief that the federal government intends to charge me with crimes. If so, these charges will be entirely false, based on lies. But they would not be surprising. I always knew that if I stood my ground for all of you, that I would be a target, and a target I became. For months, leaks and rumors have been aimed at me in an attempt to undermine my credibility and paint me as guilty. Just this past week, they searched the home of our new police commissioner, looking for documents from 20 years ago, just 1 week after he joined my administration. Enough. I will fight these injustices with every ounce of my strength and my spirit. If I'm charged, I know I am innocent. I will request an immediate trials so the New Yorkers can hear the truth. New Yorkers know my story. They know where I come from. I have been fighting injustice my entire life. That fight has continued as your mayor. Despite our pleas, when the federal government did nothing as its broken immigration policies overloaded our shelter system with no relief, I put the people of New York before party and politics. Now, if I am charged, many may say I should resign because I cannot manage the city while fighting the case. I can also understand how everyday New Yorkers will be concerned that I cannot do my job while I face accusation. But I have been facing these lies for months since I began to speak out for all of you and their investigation started. Yet the city has continued to improve. Make no mistake, you elected me to lead this city, and lead it I will. I humbly ask for your prayers and your patience as we see this through. God bless you, and God bless the city of New York. Thank you.
All right, so there's Mayor Adams' response. We don't know exactly when that was taped. We do know that we have a live look outside the governor's mansion in New York City. Details about the exact accusations in the indictment are still unclear as the indictment is sealed, but sources tell Fox 5 New York that it will be unsealed on Thursday morning.
Y'all, there's so much craziness going on. Whoever saw that coming? I thought Mayor Adams, apparently, I thought he was like everybody's, darling child. I would never have thought that Mayor Adams would have. Now, granted, I couldn't say everybody's darling. I take that back. I didn't think that people had a disagreement with Mayor Adams. I thought it was something on my beard. What is that? Okay. I didn't think people had a problem with Mayor Adams as much as I thought Mayor Adams had a lot of support in New York City, in New York State. But if they've been investigating for months, man, that's kind of crazy. And who knows, man, this is going to be wild. Now, I do have another follow-up on that because he mentioned it in his prepared speech that people have been coming for him to step down. So let's look at that real quick and then hear what y'all saying.
But a new storm of controversy tonight from the south suburbs. Dalton's mayor and Thornton Township Supervisor Tiffany Henyard faced off with trustees and neighbors once again. It's all about the money. Our Jermont Terry is live right now with what this fight was about tonight. Jermont?
Joe, this board is currently operating without a fiscal budget, and some trustees are demanding Tiffany Henyard, who is the supervisor here at Thornton Township, become way more transparent when it comes to spending. And
hey, Jason, maybe you should actually use the right video. How about that one, my guy? I'm like, wait, that's not the right video. No, that's the wrong video, my guy. That's the one about Tiffany Henyard. Which, by the way, that is some pretty shadiness, too. There's some epic shadiness there as well, but it's not about Mayor Adams. We'll finish this one up because it is interesting, but it's not about Mayor Adams. That was a technical error. I'm going to have editor Jason fix that when we upload this video. Let's try again.
Controversy tonight from the south suburbs. Dalton's mayor and Thornton Township Supervisor Tiffany Henyard faced off with trustees and neighbors once again. It's all about the money. Our Jermont Terry is live right now with what this fight was about tonight. Jermont?
Joe, this board is currently operating without a fiscal budget, and some trustees are demanding Tiffany Henyard, who is the supervisor here at Thornton Township, become way more transparent when it comes to spending. And that encompasses 17 south and suburban communities.
Lori Lightfoot did such a great job in Dalton. I will welcome her to come and do the same thing here at Thornton Township.
Calls for investigations and access to spending. That's what Thornton Township trustees are demanding, claiming items not approved by the board keep showing up for approval.
Voted not to approve, and then somehow magically they end up on the credit card list.
You're going to have to point
and
that out.
That's one of the reasons we're doing this.
Yet Tiffany Henyard, the township supervisor, says the board is showboating.
This is what I mean about my board. It's a lot of hate, jealousy, and envy amongst them towards their supervisor.
While Henyard calls it hate, her efforts to keep a community senior bingo program operating failed due to questionable spending.
It was presented that all the prizes were donated, but that is not the case. The prizes for bingo are being purchased by Thornton Township.
And they argue the expenses are out of control.
This dysfunctional board wants to take it away. That's sad, because they got nothing else to do.
Henyard tried to get an audit of the past 10 years, claiming the township was in financial ruins before she arrived. Yet the board approved to have an audit for only 3 years ago when Henyard was appointed.
I am the leader for Thornton Township. I am the supervisor of Thornton Township. And I'm going to make sure y'all give me my respect and stop playing these games every time you come to the meeting.
Supervisor, you're out of order.
You out of order. You out of order. Moving on.
Respect is earned and it's not demanded.
Things got heated during public comment after someone compared Henyard to an animal. Police were called. Now, Henyard claims that she was able to get the township out of a deficit, and while she's making those claims, she hasn't provided any documentation to prove it. Reporting live in South Holland tonight, Jermont Terry, CBS News, Chicago. Joe?
Jermont, thank you.
I don't know. I have no idea why it is that so many government officials are starting to be exposed now. If you just go down the rabbit hole. Matter of fact, this is a YSL free day. So you can kind of go down the rabbit hole. You can look at the mayor of Chicago, the mayor of New York, the mayor of Dalton, New Orleans, the mayor in Oakland, California. There are so many of them. It almost seems like what's going on? Like, why are there so many mayors and elected officials? And then we can dig, and those are mayors. So we can go down layers lower, like lieutenant governors and commissioners. Like the Fulton County Commission here in Fulton County, Georgia, is a hot mess. Then we can go to judges. Y'all remember that Peterson judge here in Douglas County, Georgia. And there's so many layers. Like, now I'm not saying pretending like I don't already know the issue, is that we're sinners. We're flawed individuals, and we make sinful decisions, and we make mistakes and try to cover them up and cover those up and cover the cover that covers up, and so on and so forth. It just seems really interesting. So much of it's coming ahead right now. And then, of course, we could talk about, those are elected officials. We could talk about prominent names, because again, that P. Diddy thing is going to go south real quick, because I don't believe that Sean P. Diddy Combs is going to take that L all by himself. I think he is going to probably give up every name, every phone number, every video, whatever. He's going to take everybody with him if possible. So there's a lot going on. I just think it's super interesting. It is really, I find it just engaging, to say the least. And, where we are right now, and we haven't even talked about the election. We haven't even talked about some of the shenanigans swirling around that. So it just seems like a really interesting time. So again, I know I called Cat Williams a prophet. I was just being tongue in cheek, but I do think it's fair to say that what Cat Williams said on the Shannon Sharp show back in February was pretty on the button, on the nose, that 2024 was going to be really wild, and he did not lie at all. Let me see what y'all say. And if you want to, because we're not going to be super long today, I'll go ahead and drop the link in the chat. If you want to jump on, please make sure. I'd love to hear what your thoughts are, whether it be about the Young Dolph case, if you want to talk about YSL, you want to talk about what's going on with Mayor Adams up in New York, or Tiffany in Lower Chicago, whatever. Feel free. I dropped the link in the chat. Feel free. All I ask is that you have your camera on, that you, of course, have your camera on. Keep the language, of course, PG, and obviously stay on task. Thank you so much. All right. Yeah, he's going to bring a lot of people down with him. I think that's going to be very interesting what happens with the P. Diddy case. Cat Williams called 2024, all secrets will be revealed. Finally, some accountability and justice. I think that's interesting. I do want to see how it shakes out, for sure. Social media is a lot of these gang members' downfall. Let's just say it like that. Hey, by the way, does anybody know, we're just kind of jumping around, with the cell phone data, they can tell if you get a text message, but they can't tell what the text message is. They can tell if you make a phone call, and of course, if they got a wiretap, they can record what the wiretap is. Can they capture FaceTimes? And then also, like, a lot of iPhone users like to drop their location and put like a pin and is kind of tells their friends where they are so they can find them. Can they capture that information? I just was wondering. There's not any case particularly that I'm referring to. I just wonder, can the the cell phone companies be capture that data, the FaceTime data, and then also the when you drop a pin or location. I think Ron is saying no to that. All right. Okay, let me see. Wait, I think somebody said right here. I don't think they can because I remember Woody saying that that's why they would FaceTime. I could be wrong. Okay. Okay, but can they tell that it was a FaceTime? That's what I'm saying. Like, even that, if they can't capture it, like wiretap it, can they see like, oh, Jason made a FaceTime to Tracy Thomas? Can they at least see that, or is it not, or is that just totally in the dark? They said they can't capture FaceTime from cell phone companies. Okay, thank you, my favorite firstborn child. Thank you so much. What are you doing, like gang signs? Please stop that. Stop. I want you. You're already in the gang, in the Afro gang. Bye, baby. What y'all get? What did you all get? Some ice cream. They said no to the FaceTime. Okay. All right, cool. And what about the dropping pin location? Can they do that? Do you know? And jump on. Wait, I got Antonio in the building. Why didn't I hear it?
Big brother. Why not, big brother? How you doing, man?
Grace and peace, man. I'm sorry, Mr. Antonio Sinclair. How are you?
Man, I'm cool. I'm good out here, brother, man. I'm new to the channel, man, and but I've been seeing your content floating, man. So I was on here one day, man, and just was commenting, and somebody gave me a subscription. So, man, I think I'm gonna continue to renew it and keep it going, man.
Well,
you got
you, man.
great content, big brother. Man,
Appreciate
big brother, you got great content, man. I follow a lot of them, but man, you one of a kind, man. God's grace and hand is on your platform, man,
well,
and I
you,
enjoy it, man.
Thank you, man.
But
now,
my thing is this. I think two-part question. Well, not two-part question, but two-part response. The Young Dolph situation. I think them dudes gonna get found guilty. And I think, like you said earlier, the RICO is already in motion.
Rico is
you
already
can believe
on the stove.
it. Yeah. He
already.
cooking. Yeah. Baby boy cooking. He seasoned up and everything. He don't marinate it and everything. So I think the guy that was in contact with Jook, the one that's locked up that made bond, I think he's gonna be the one that they're gonna apply the pressure to. That's gonna blow it all the way up, along with the guy that testified on the stand.
I like it. Yeah, it's definitely interesting to say the least.
Yeah, it really is, man. Yeah,
day one, he spilled all the beans on the first day. We're like, whoa!
Out the gate, like a horse at the Kentucky Derby. Out the gate, man. He wastes no time, and that says a lot. That says a lot to what evidence and what they got, because I don't support what if you out there and you doing what you're doing, the consequences behind the choices and the decisions that you make when it comes to situations like that. So I don't condone the snitching, but at the same time, I did 10 years in the Fed, so I know how it feels for somebody to snitch on you. You know what I mean?
Sure.
So I'm not a proponent of it. I hate it because you're a grown man. You know what you're doing. You know the consequences to the street code. Point blank. No excuse. And if I can flip over to the Young Thug trial, this Tennessee case makes that case look real bad, man. Absolutely. It makes the state of Georgia look terrible. They ought to be ashamed of themselves, man, that they can get a high-profile murder case that I think Dolph case been going on for like 2-3 years, almost the same time.
November 21.
21, almost around the same time when Thug them got picked up. I'm assuming.
Yep.
Almost around that time, and they are done. Oh man, that says a lot, big brother.
We got to hang our heads up in here, Georgia.
Man,
for sure.
Man, Georgia need to get it together, man. Georgia, and that's one of my favorite states.
Yeah, but Georgia, Atlanta must be stopped. Let me ask you this, if you don't mind me asking.
Mm-hmm.
Now you said that you've spent 10 years in the Fed. I don't
Mm-hmm.
want to know what you did, but I do
Mm-hmm.
want to ask you because I'm getting just looking at what I'm seeing right here. You seem
Uh-huh.
like you're a gainful employed individual.
Yes, sir. Yes,
Is
sir.
it difficult for a street dude to become a legitimate dude? Is that difficult?
No, no, it's not difficulty. I think what comes into play is, I'm a born again believer. I'm a born
Fact.
again.
Praise
I
God.
love the
Yes.
Lord. I'm saved. You know what I mean? No shade to nobody else or what their belief is. But I know what worked for me, DWC. You feel what I'm saying?
Okay.
Born and raised in the church. But to answer your question, no, it's not hard because I knew that if I can take the same mentality I had of hustling drugs as a kingpin, and if I can use those same principles and business mindset ethics in the legal field, that I can get ahead. If
You
that
mean
makes
in a
sense.
legal field, right? In
I
a
mean,
legal field.
legally. Yeah,
Yes, yes. There we
legally.
go.
Going to get me a job. I started from the bottom. When I got out in 2009, I worked for $8.25 at a Chipotle Mexican grill. Walked every day from the halfway house for 6 months all the way to work. And I was the type of guy I was getting it. I'm not
Yeah.
tooting my horn, but I made a decision in my mind that I'm not going back that route. So I don't care if I had to go work three $8.25 jobs to make it. That was not an option going back that way. So guys have to have their mindset change when they come out and want to do right because it's out here.
For sure.
It's a struggle. I'm not gonna even sit here in front and tell you that, when you go get these jobs and they ask you, have you been convicted of a felony? Most of them ask you have you been convicted in the last 7 years? And what guys don't know is that if you was convicted before those around 7 years, and you got out, you're no longer considered to put that on your application that I've been convicted of a felon in the last 7 years because you've been incarcerated for the last 7 years. So that was a lot of the loopholes that I had that allowed me to get some of the jobs that I had. And now I'm a CDL owner, you know what I'm saying? And I own my own truck.
Okay.
So
Yeah. I kind of want to know, like, this is a great story, man. Antonio, do not ever, if I ever drop the link, you're welcome. You're
yes,
to
sir.
come on and we can talk about it for sure. Where are you?
I'm in Charlotte, North Carolina. I'm
Okay.
originally from Orlando, Florida. I got a
Okay.
deep testimony, man. I don't have the time to really lay it out. I live in a glass house because I understand that what I went through was not just only for me and my sons, but it's for other young youth that are coming up in society today that are being tricked mentally, man, by the things that they see by our own community and the platforms that they sit on and the poison that they push into our community. So I got a real story to tell, man. It's not a felonious one.
No. What we're going to do is we're going to have a day. Maybe shoot me an email,
Okay.
dearwokec@gmail.com. Maybe we'll have a
Okay.
day and just have you come on. I would love to hear your story.
Yeah, man.
What do you carry?
I'm actually running for Sharon Williams right now.
Okay.
My truck, I have somebody in my truck running it for me. So I'm basically burning the candle at both ends. So to God be the glory. I got to keep some seed in the ground, man. You know what I'm talking about?
I got you. Now, if you want to come by here, I need some paint over on these walls now.
Hey, man. Hey, I got you, man. I'll shoot you my email, man. You know what I'm saying? You can go get my discount. I definitely will. I know it's better to give than to receive, brother. And that's how I'm able to be where I am, man. And I just try to spread it and I try to share it with everybody, man, that has been down the road that I've been down and that are trying to come out, man. You know what I mean? That are really wanting to do the right stuff.
How about this one, man, Antonio? Because I really like your story so far.
Uh-huh.
Speak to the young cats that we've been talking about on this YSL trial. The Woodies, the Zacharys, the Antonio Sledges. We ain't trying to down those brothers, but maybe give them an opportunity. Share some game that can help them get out of the loop. Because it sounds like you've gotten out of the gravitational pull of the street.
Mm-hmm.
And now you're driving on the street, but I like that.
Yeah.
So
yeah. Yeah.
Break it down to
Yeah.
us.
The thing of it is, man, you know, we've always said that people are a product of their environment. Well, I disagree with that because LeBron came from a household with a single mother, without a father, had a community that was able to get behind him and push him. So for people to say that they are a product of their environment, no, we're actually a product of our decisions and our choices. And speaking to the Woodies and speaking to the Sledges and speaking to the little D's, first and foremost, they got to get out of the mindset that somebody owed them anything. First and foremost, we wake up with chances and choices. Now, what you do with your two chances and choices that you get in life is all on your decision making. You don't have to go out there and stand on a corner. You don't have to go out there and have to be a hood legend with no type of value. Because as I look at these young brothers now, man, and I hear a lot of people say, oh, you know, old Woody, old this, but if you see what he's doing now, the behavior haven't changed. It's just now I got money, I got a little money, a little notoriety, and now I can even take it further. Now, if he was doing it in the right way to turn it around and make it out of positivity, but you know, with all the money you showing on the camera, that's nobody's business. That's street ignorance. You know,
Right.
so it starts right there. They got to get that out of their head, you know, and get around people that can help them in a way to be educated and to be positive. But they first got to think about, you know, is my respect is more loyal to the streets or to my daughter? You know what I mean? Because what's gonna happen when you die for the street for respect, but then your daughter is left out here without a dad, or your son is in the penal system? What happens? The streets continue to move on. The streets continue to evolve. The streets continue to change. It loves nobody. You know, the bomb today could be a billionaire tomorrow out of one decision, you know? So I just think that they first of all need to get out their environment, because you can't go back to the same environment with the same type thinking and think you're gonna change. Because at the end of the day, you got young kids coming up in the ranks that are seeing what you did. You know, you understand quote unquote street terminology. You a rat. You know, you don't think nobody might. You know, you think you Mr. Invisible, and now you flaunting in front of people's face. So it's dangerous. It's real dangerous, because first of all, the enemy don't care who he gets to use. You know, once he gets you out there, he poked the hole in the boat and he just sitting back laughing. So it's dangerous to me, big brother, that, you know, I see him on IG and I see him on these platforms, and, you know, these six brothers sitting in here fighting for their life. You know, out of just sheer respect, man, just go hide. Just go lay down somewhere, because you don't even know if these people will come back and throw charges back on you again. You know, you're not out the weeds. So, you know, I just think that they just need to really get their life together and really get their mindset together and get away from the environment. You know, it's not the same. It's not the same.
Man,
you know,
Antonio, man, thank you so much for that, brother.
Man, blessings to you, brother.
Brother, I'm glad I looked down and said, wait, there's somebody that hopped up in the chat. Then hopped up on the screen. I'm glad I did that, man. Again, Antonio, I want you to drive safely, brother. Thank you so much from North Carolina. You are welcome. Whenever, shoot me an email.
Yes, sir, I will.
Your story and all of that good jazz. I'm gonna let you drive safely. Don't forget, you know, don't forget Whitaker Park. We might need some paint, so I'll.
Okay. Hey, listen, we'll connect. I come down to Atlanta all the time, man. Cause one of my spots is Flavor Rich and Papa Doc. So I might be Papa Do's. I might be down there in 2 weeks. So I got a friend that's opening up a candle wax shop down there. She's launching it on the 12th of October, and I'll be down there. So I'll shoot you my email and my information, and we can hook up, man, if you're in the area, man. I'd like to treat you to lunch and sit down with you, man, if that's okay with you, big bro.
Let's make it something fun. Let's make it fun for sure. You shoot me an
Let,
email. We will
let's
make
do
sure
it.
we
Let's do
connect.
it. Even if the family involved, man. You know, I'll be with my wife and my daughter. So, you know, if you want to bring the
Absolutely.
wife and the girls, man, you know, feel free, man. But I
We'll bring the
definitely shoot
Dangerous
you my
crew.
information when I get off here, big brother.
Sounds great, man. Thank you so much, brother.
Thank you,
Travel
big
well.
brother. Salute to
You
you.
got it. Grace and peace.
Yes, sir.
Y'all go ahead. That was good. I'm glad I did that. Y'all, let's drop Antonio in the chat. I'm glad that he stopped by. Man, that was good encouragement. And to hear that, you know what, it is possible for a street dude to turn from the street. And now he's driving on the street. How about that? How crazy is that? So yeah, shout out to Antonio, man. If he comes back through, if I ever get a chance, hey, he comes to Atlanta. I would love to have him come on and rap with him. Yeah, absolutely. Be safe out there. But now that was a good story. I'm glad to hear. Now again, I don't think he made it sound like it was easy peasy to snap your finger and a street dude becomes a legitimate citizen. He did say there was a lot of work that goes into it, but I think that's what most of us have said about Woody, and most of us said about those other gentlemen in the YSL trial is that, you know what, they need somebody to pull them out. They need to have some motivation to get themselves out. They need to be in an environment that helps push them out of that system. So yeah, shout out to Antonio, man. That was good to hear. I'm glad we had a chance to catch up with him. Shout out to him and whoever gave him the membership. He said, shout out to y'all. So again, thank y'all so much. What are you saying right here? Trey L says, I believe Woody, Sledge, QZ all have remorse and feel bad about the choices that they made in the past. No question about it. I think all of us are like, look, we got consequences now. Nobody's absolving consequences at all. So I do believe that you can have some negative feelings about things that you've done, and prayerfully those negative feelings will motivate you to make better decisions in the future. So yeah, shout out. Thank you so much, Trey. That's a great comment. Hey, that was fun. I'm glad. Hey, I'm glad I dropped the link because that was a good conversation. I like hearing good stuff, and that one was a pleasant surprise for sure. Now, granted, I'm a little bit bitter because he got a lot of sunshine up there in North Carolina, and we are not sunshiny over here. It is raining here. And the Dangerous crew just got back. So yeah, I think he's still in that environment too. He is still in an environment, trail. And that is part of the problem. But if you think about it, if you're used to flexing and all of this on the social, which by the way is just social media, if you're doing all this stuff, and then to what Antonio's talking about, or what most of us are talking about, is saying take a step down. He said when he got out of prison, he was making $825. Like you a dude over here making a whole lot more than $825. We telling you to go legal, go legitimate, be a virtuous person, and make $825. That's you gotta. Whew, that's gonna take a major shift. So hopefully, we can see that. That'd be great, though. Oh, you know what? He's from North Carolina. You're right. He's from North Carolina. Wherever Antonio was, it was sunshiny, and I'm a little bit jealous. There we go. Maybe I should have said it differently. Thank you, Gene Lee. Thank you so much. But yeah, man, that was cool. And hopefully we'll have a chance to have Antonio back on. I want to hear a story. That'd be something different. Different for the dear woke Christian nation, but hopefully something that everybody can find good value in and enjoy. Y'all, it's been a great morning. It's been a great morning. We got a lot going on tomorrow. Court should be back in session tomorrow. So we'll be back up in the booth, 8:15, 8:30-ish, causing trouble, causing chaos over there in one Charlie. So far, I'm assuming that Investigator Sprinkle will be back. Now, I don't know how much longer Adrian Love had in examining him. I think it was Adrian Love that was examining him, or Hilton. But Sprinkle should be back tomorrow because they were just finishing up with the cell phone guy. And then Sprinkle should be back. I don't know how long he's going to be, but if they get done, then there'll probably be another witness, whatever like that. And then that's the week. And so that should be good. On tomorrow, Friday evening at 7:00, I have a special guest. I have Doug Weinstein coming to the channel. We're going to chop it up. So if you don't mind, down in the chat, down in the comments, let me know what questions you would have for Doug. I got a better one. Yeah, leave your question there. I'll try to give him some questions from you all. I have some questions for him. But I do want to ask some questions that you all have. So down in the comments of this video, let me know what questions you would have for Doug. And hopefully he'll be here ready to answer them all. So of course, I'll take some questions from the audience in real time as well. But I do want to make sure I give him as much opportunity to answer as many of your questions as possible. Now, if you see a question that's already the same, example being, what do you think about Adrian Love? There's not going to be a real good reason for you to type, do you like Adrian Love? So we already know that the question is already out there. So leave your questions. So we'll do that tomorrow, Friday, and on Sunday. I'm going to do a wrap up and kind of build up for the week. We're going to go over the Young Dolph case. We'll talk about the case in Jacksonville, Tampa, the Julio Fulio case, and of course, anything going on with Diddy in New York, as well as here in Atlanta, the YSL trial. There's a lot going on. I believe next week we have a special interview around the Karen Reed trial plan. So keep your eyes on the community post. The community post is going to be hopping and popping. Wait, you heard no court tomorrow? Really? No, it's not. No. Really? Okay. If there's not, let's do that. You gonna ask Doug to teach you how to Dougie? If you do that, I'm gonna put you in 0-second timeout. I will put you in 0-second timeout, Trey L, if you do that. Because but I got a feeling Doug Weinstein probably has got some skills. He probably got some Dougie skills. Are you for real though? Are you for real? Course closed, or are you just saying that? Okay, man. I mean, it could be. I wouldn't be surprised, but the weather has been really not that bad at all. Not even a little bit. Now, of course, something could happen, but yeah, court has not been bad at all. So yeah, but rain ain't now look, Georgia, we can be pretty soft and pretty weak, but let's not start shutting stuff down just because it's raining. Now, if it's gonna be wind and flooding, I got you, but let's not start shutting everything down because of rain. We've done that before, Georgia. We've looked crazy. Who is that other guy? Who is that other guy there? And how will the defense address that? Who's that guy? I don't know who you mean, Trail. I'm assuming you mean the YSL trial, but tell me what you mean specifically. I would love to. I'd love to see if there's something I can explain if I understand it. No, great commentary in the chat. Y'all are great. So tomorrow we'll be doing that good old interview with Doug Weinstein. If there is no trial tomorrow, okay, so let's just say that if there is no court tomorrow, we'll probably do another show like this, kind of going through a lot of different things going on that are in cases and whatnot like that. Maybe I can get Monica Mo Justice to stop through, or Black law student, something like that, to come through and give some 2 cents. I think that'd be fun. Let me make sure. Oh, the one that has life. Yeah, that's a great question. Why is he here? Why is Little Rondarius Ryan, why is he here? I know you're talking about now. So really? Wait, who's she? Thank you so much, Serena. Who is she? Man, if they don't have court tomorrow, well, okay, that's fine. If they don't have court tomorrow, we'll probably start around 10. I'm gonna get up in the morning and take my car to the shop and run the Dangerous Crew to breakfast. But if they don't have court tomorrow, we'll probably start around 10, 11 o'clock. We'll probably do another montage of just different cases and such like that, and get ready for our Doug Weinstein interview at 7 o'clock p.m. But we're not going to go all day, though, till 7 o'clock. I'm not going to do that. Lil Rod is there for ambiance window dressing. Well, I mean, that's kind of true. And the bad thing is he's getting in trouble. Like he's the reason why they had to swap seats in the courtroom, because they want to be able to keep an eye on him, because he had contraband in court. I mean, not in court, but in the jail. So those kind of things like that. I don't understand what the purpose of him why he's there. Why is he brought up in there? Especially when none of the men there, as far as I know, have any relationship with him. So he's a part of a gang. He's a part of the conspiracy. He's a part of the RICO, and nobody even knows who he is. That's crazy. But so if you don't mind, if you run across it tonight, let me know. Shoot me an email, Dear Woke C. Let me put that in the chat as well, dearwokec@gmail.com. Or if you're in the Discord, let me know. If there is no court, we'll start a little late tomorrow. But if there is court tomorrow, we'll be starting around 8:15-ish, 8:30. And I'll make sure I put up a thumbnail so you know ahead of time. And y'all, thank you so much. It's been a lot of fun. Always a great time. Thank you so much to the moderators. Thank you again, Cull Obsidian, with a very kind super. Appreciate you, brother. My YSL free day was pretty good. So I appreciate all of y'all. Yeah, I would love to ask. Maybe we want to ask Doug some questions about the jury in general, not about this specific jury, because we don't want it to sound like we're trying to sway a jury. But like, maybe we could ask them some general questions about juries in general. I think that would be interesting. Doug Weinstein is a defense for Yak Gotti. And he's the gentleman. He really has, let me see. He did a great job yesterday. I got a little clip of him. I got a little clip somewhere. I didn't have it ready, so I apologize about that. But y'all have seen him. Y'all know who Doug is. Yeah, I don't have that clip ready. I don't know where it is. But really nice guy. Super. He's the one that's definitely very. Oh, now y'all saying who. So now I got to bring it in. So y'all don't think I'm lying. Right. Doug Weinstein, he's always, no matter how cantankerous a witness is, Doug Weinstein always comes up and is very kind to them. And he comes across like just really, almost like he wants to give the people a hug. He comes across really nice to people. And I think that's a great strategy. Not trying to say he's doing it for ill motives, but I think it definitely contrasts, because he usually comes right on the heels of, like, here he is right here. All right. He usually comes on the heels of somebody like an Adrian Love or whatever like that. Here, I'll just pull this in real quick. You know what? Here, just get us warmed up. I was literally about to shut it down, but I said, hey. All right, let's check this out.
He has been representing Yak Gotti.
You've stated repeatedly that you would tell the police anything to stay out of jail, right?
Yes. His name is Doug Weinstein. You know him well. I said he's been there for 427 years, and he looks pretty good as Jonathan the Vampire, because he may never get out. And according to the state, if you have red behind you, that means somehow you're a killer, and you're in a gang, and you're responsible for any other person that may be in the picture. So we're coming in the picture. Michael, you and I are now gang members. We could be charged in Atlanta, Georgia. Doug, I want you to give me everything. I want you to tell me everything that's happened recently, and what's going on in this trial.
I like her.
What is this case? Is it like flying an airplane where you get days and days of dullness and then moments of terror?
And we have this new judge here, but quite frankly, she's not really moving things along that much. I mean, I think she's giving the prosecutors a harder time. I mean, they don't go in and saying, ha, 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 I can just argue it all. But you've got a person on trial here. You've got a client on trial here.
Yeah.
And I know he did. I was watching today, Take It to Trial, the rap he did with Young Thug, Yak Gotti, and Gunna. And again, I'll say you represent Yak Gotti. For those who don't know who he is Diamante Cap World. His career was just really taking off.
Yeah.
And now, I just read something. This case is going to go to 2027. Is that possible?
Let's talk about recent outrages. How's this? It's not this week, because this week's only a day old. But I'm sure by the end of the day tomorrow we'll have an outrage. The last week was the end of a witness that the state said was going to take 3 hours of direct examination. That witness was on the stand for a week. And they said it was going to take 3 hours. Now the state will say, well, the witness was uncooperative and blah, blah. Well, all of their witnesses are uncooperative, right? All of their witnesses aren't testifying the way they want them to testify. So it should have been no surprise. So yeah, back in March of this year, I have to think of the year, March of 24, I filed a motion with the previous judge, and based on how many witnesses they had, I said, well, this case is going to go to 2027. That's when they had 700 witnesses on their witness list. They've got about 100 witnesses left. They've been through roughly 100. So right now I'm predicting summer of 2025. Meanwhile, I renewed my motion to limit the time the state had to present their case, because I think they've been so abusive in their lackadaisical attitude on presenting witnesses. Meanwhile, my client's locked up at Rice Street. So after that 3-hour witness took a week, I renewed my motion. And of course, the judge turned it down. But all I can do is nudge, right? All I can do is bother the court as frequently as I can, saying, we got to move this along. If this isn't going to move, if my client's out on the street, that's one thing. But when he's locked up in Rice Street, that's another. And there's no effort to move at any kind of deliberate pace from the state.
Doug, let me ask you this. And for those who don't have the bigger picture here, this is a RICO case. Mr. Williams, Young Thug, the primary defendant of the 6 now on trial. Where does your guy fit into the mix, Yak Gotti?
Sure. Well, my client is, as you said, he is a rapper. He is signed to the YSL record label. He's done he has multiple cuts that have been released alone and along with Young Thug, Jeffrey Williams. How does he fit in according to the state in this ridiculous indictment? They accuse him of course, racketeering. All 6 defendants currently on trial are accused of racketeering. In addition to that, they are accusing him of the murder of Donovan Thomas, known as Peanut. They're accusing him of multiple overt acts, including such outrageous actions as recording rap lyrics, as some of his overt acts. And they accuse him, as far as other acts, they accuse him of when they went and they raided Jeffrey Williams' home, Young Thug's home, in May of 2022. My client, Diamante Kendrick, was there, and they found some guns in the home. They found some drugs in the home. And even though all kinds of folks were in and out of that house, they're trying to hang that on my client. So they're accusing him of some gang activity, possession of firearms, possession of drugs. So a few other charges as well. But the main charges are the charges of racketeering as well as murder.
Here's what I don't get. And, I tried the Spectre case in California, and that was like 6 months. And I said, in California, 3-week trial will take 6 months. I never thought that in Georgia would take, 3 or 4 years. And I talked to the Georgia defenders a few years back, just before COVID, and they said, well, you don't know how bad it is down here, right? I was with Barry Scheck and the Innocence Project and some people about how you put forensic evidence in and DNA and all that kind of stuff. And now that I see this, I certainly would have done my lecture differently, but there's somebody on trial who's pled guilty and then his plea to some other crimes. I think it's and his plea was undone, right, by the Georgia Supreme Court, saying it was coerced, if I recall.
That was a different individual.
Different individual. Okay.
That wasn't Gunna. Gunna did plea in this case, and he got time served plus I don't know how many years of probation that he got.
Because I'm sure the state is forcing people like Lil Woody, who was my favorite witness of all time, or Little Woody, I guess I should say. Woody, I guess I should say. The states have bases how they do that, but in this case, there was a judge who said, hey, I'm going to, on that other client, I'm going to not treat you very fairly at trial if you don't plead. So pled. It was reversed on appeal by the Georgia Supreme Court. Blah, blah, blah. Came back and he had an Alford plea because he had spent 5 years in jail. And now they're using the same stuff against him to say, hey, he's part of a RICO claim. And I only bring that up because it's so outrageous that it would happen against him. You have a client who's been sitting in jail who says, hey, I'm not guilty. And the lyrics are one of the biggest things against him.
Yeah, I have fought before, and I'll continue to fight the use of lyrics against my client. I think that, and I don't need to go into it all, but I guess because of this case, because of this case, I have spent, I don't know how much time researching the use of lyrics. And I'll tell you this, big picture wise, lyrics are only used against people of color. Those are the only folks lyrics are used against. And so people will say some racist things like, well, those are the only ones that get in trouble. But that's not the case at all. Those are not the only artists that get into trouble. When I argued this before Judge Glanville in, oh my gosh, November of 2023, I've got to think of the year. I put up 6, 7, 8 examples of country music singers who have lyrics. Those lyrics, there's a nexus, there's a connection between those lyrics and the crimes they were accused of. And those lyrics were never used against those country singers because folks understand that in country music, not every lyric is autobiographical, So, but for some reason,
I always sing Johnny Cash. I shot a man, just to watch him.
Yeah, and
I
you know
always
what?
sing that. Terribly.
Right, and the state was prepared for me to use that Johnny Cash lyric, and they were prepared for me to use the Bob Marley lyric about I shot the sheriff.
Right.
But I don't think those are the best examples because those individuals were not charged with crimes, and they weren't charged with crimes. So those are easy ones for the state to shoot down. But I used very specific incidents of lyrics that were written that had some connection to the crime charge and they weren't used. And I'll tell you how racist it is. It assumes that people of color cannot come up with these lyrics unless they're autobiographical. It is incredibly offensive. So you have that. You have all the First Amendment issues. But I'll tell you one thing. If you look at all the cases where lyrics are used, what you will find is there is some connection between the lyric and the crime charge. In the case with my client, Diamante Kendrick, who sings under Yak Gotti, that's his stage name, the lyrics they want to use against him have absolutely no connection to the crimes that they've charged him with. They talk about things like, I don't know, bodies on bodies or take it to trial or whatever it is. And they're not accusing him of any of these things. So these lyrics are used purely to inflame the jury.
Yeah. I mean, in the best case scenario, if there's corroboration and that's one more little something, maybe, I don't like it at all, but maybe in that scenario, maybe. But I think this is outrageous. It really is.
In that case, I can maybe understand it a little bit. I would still fight against it.
I'm going as far as I can.
Right. Yeah. I would still argue against it.
Of course.
But where there's no connection, it's just bad. I don't think it's anything other than artistic expression. But there's so many ways you could keep this out. Bad character evidence. I mean, you two know.
Let me ask a question.
Yeah.
Linda talked about Lil Woody because I was looking again at some of your cross-exam of him, where I think you
you're great.
Yeah, I think you used the legal term bullshit, as I recall.
I did. I use that term bullshit.
You've heard the word, I'm just going to say it once. You've heard the word bullshit a bunch the past couple of days.
Right.
So we'll just say BS. Is that basically what you were telling the police, BS?
Yes.
So you're a bullshit artist. You're a BS artist. At
As
the
you can
time.
see.
I'm sorry.
I said, as you can see.
Okay. Or at least you were several years ago, correct?
And I told them that.
Okay.
You were basically saying, dude, we all know you're a liar. You're always a liar. So apparently you had some come to Jesus meeting or moment, and now what you're saying here on the stand is not a lie. How do you think his testimony on the whole played out for this jury?
On the whole, I would say on the whole, if I were a juror, I would say I put no credibility in anything that he has to say. I would throw out everything about me personally. I'd throw out everything that Lil Woody said, whether he said it to the cops, even maybe to some degree, whether he said it on the stand. I'm not sure. I think that he may have been telling the truth on the stand this time. I mean, I watched him early in his testimony do the thing, and I think I mentioned this in my cross, where he raised his hand and he said, my hand to God, Everything I said before was a lie. I'm telling the truth right now. And I didn't think a lot of it at the time until I stumbled on an interview that he gave in early August, where he really did seem extremely sincere about understanding that, well, maybe God does exist because of these things that happened in my life. So I think I took an unusual tack in my cross in that I asked him open-ended questions versus leading questions, because I thought if the jury could see him saying in his own words about his recognizing that God existed, and thus I think giving credibility to his statement, my hand to God, what I'm saying here's the truth, and what I said before was a lie. I thought that might be effective. And of course, in my cross, I had the benefit of knowing that I had Brian Steele and Max Sharp behind me who would go into incredible detail on all these other issues. So I could stick to kind of bigger points, bigger issues, and they would be there to back me up and go into all the detail and dot the I's and cross the T's. So I didn't have to worry about that.
Although I always have wanted to say in a trial, everything that guy said is bullshit. You know, for those of us who are old enough to remember the movie My Cousin Vinny. But, you know, when he says, hey, I'm finessing the police, yeah, that's what they do. That's
Of course.
He's not going to be a snitch. He's finessing those who want to hear what they want to hear to get where they want to go, even if it's not the truth.
I think he was even.
Yeah, go ahead. I'm sorry.
He was even sympathetic. You know, he's talking about being shot at when he's holding his kid.
Yeah.
You know, hey, Linda, I'm going to do something horrible here because I'm going to have to run because people may notice I'm not in my normal location. This is almost a tease for a new feature on Justice Served, which is called "Where in the World is Justice?" And that's I can't tell you where I am, exactly what I'm doing, except that I'm going to have to run. So, Linda, please get the last question in here, or I'll let you guys stick around and talk.
No, I'd like to have Doug on as much as I can. If he wants to come on once a week, twice a week, whatever he wants to come on, even if it's live or we just tape it for 5 seconds, 5 minutes, because I think, Doug, this is such an important case. I also think you have such great lawyering between you and Brian Steele, Mr. Adams, Max Sharp, and an appearance by my friend Ashley Merchant, who represents Brian Steele. And what the hell is going on in Fulton County? But I want to talk further with you in another aspect as to why I think that there's a possibility the Fed should come in and look at indicting these prosecutors. I know that's a big thing. It's going to have it's a big thing to say, but I really believe it after what I have seen here and what I have watched as a lawyer doing criminal defense for, 30, 40 years also.
I understand. I personally would not advocate for that. I see some actions with these prosecutors that are offensive, unprofessional, arguably unethical. But I don't know that it rises to the level of a federal investigation. I would like the feds to get involved in Rice Street, without a doubt. A federal judge needs to take control of that jail. But with the DA's office, I'm not there yet. I'm not saying I won't get there, but I'm not there yet.
I don't. And
Yeah, you can say whatever you want.
when I see
I'm
these
not holding back. I'm not holding back.
When I see these civil rights violations, I think that this case has made some of these people victims as opposed to defendants. And that's
what I will say about that, go look at my Twitter and take a look at the story about a young autistic man that passed away in Rice Street partially due to the actions of one of these prosecutors. I think an attorney, Rachel Kaufman, would say it was directly related to the actions of one of these prosecutors. And then I think that the outrage that she feels, the outrage that many of us feel about some of the actions of the win at all costs attitude of this office, call a lot of issues into question.
Well, maybe that's what we should discuss next time on. You let us know when you come on, because we're an open book for you to come on and discuss any of these issues at any time.
This case could end by mistrial, by dismissal, could be a hung jury. I doubt it'll get that far. Or it could come back on appeal if there is a conviction. Here's a new one, though. As you know, Doug, there's an election coming up. Yeah. And if Fani doesn't get reelected, her opponent said, I'm killing this case. So
yeah, but she's going to get reelected.
Oh, she's that
it's Fulton County. No, it's Fulton County.
So she's going to get elected.
She's going to get elected
because it's Fulton County.
It's Fulton
Well,
County.
I can't wait to talk more about this.
It's
and
Chinatown.
I apologize again as I continue to look for where in the world justice may be. We're going to talk again.
It was great to talk.
You're it, Doug. Thank you so much, and hopefully we'll see you next week.
Okay, so I just thought that was a good little episode. I thought that was worth stopping by and having y'all check out. I do want to talk about something else really cool. So that's Doug. Doug will be here tomorrow. Super good guy. Looking forward to it. So drop your questions down in the comments below. I'll synthesize the questions so I want to get as many questions answered as possible and give him as much time to answer your questions as possible. Something I want to point out. I'm not like a big, advocate for all of these shenanigans that are going on, but I want you to think about something. I went to Chat GPT. Chat GPT is like my office assistant. Okay. I call my office assistant. And let me just move this over. Can't move it over. There we go. I asked it to write me a rap song that would be considered thuggish with self-incriminating. I was going to say lyrics, but I didn't. So I want to point this out because you don't have to. You do realize that I'm going to show you the rap in a second. I wrote a rap song using ChatGPT. Who would you convict? Let's see what it says. Creating a rap song that's explicitly thuggish and self-incriminating would definitely be something that artists in real life have gotten in trouble for, especially if the way the lyrics are increasingly being used in courtrooms against rappers. While I can write something with a gritty street level vibe, it's important to note that I'll avoid crossing into anything that could legally be problematic if it were to be treated seriously. Here's a rap song that fits the vibe without getting too specific in self-incriminating. Now, this is from ChatGPT. Yeah, I came up from the dirt, made it out the gutter, raised by the wolves. Man, I never knew a mother. Late night hustling, dodging those lights. Had to keep the heater close, stay sharp like a knife. I mean, that's actually not bad. But again, this is ChatGPT that did this. That does not mean that you need to come in here. Leave me alone. Shut the door. Shut the door. No, get out of here. How does
I just have to tell
how
them
does
the
shut
truth.
how does shut the
I have
door
to
sound
make
like
sure
come
they
in
know
here?
the truth. My dad might be a rapper, but just know he will never be as good of a rapper as me.
Okay.
Never.
Never. I'll never be as good a rapper as you.
I came from the street.
Why? What did I do to that child? All I do is help that child out. And look at what she besmirches my rap skills. And I told you ChatGPT wrote these bars for me. Oh, let me make this zoom in a little bit better. OG on the block. They call me the chief. Kept up with my fam. Kept the fam fed while I pocket the beef. Riding through the hood. Windows down, no tint. With the money so dirty. Gotta rinse every cent. So I bring this up and I'm just dropping this. I thought this was hilarious. Like, who would be responsible for this lyrics? Let's say that these were really self-incriminating lyrics. Who would go to jail for them? And who? And we haven't even gotten into ghostwriters, that there are actual people who write rap songs and regular songs and books and the such for people that take credit for them, but that the ghostwriter never gets credit. So who's responsible for that? Like who gets held? And I just think that that's really a slippery slope. I'm not a fan of using rap lyrics in court. Now I know I think they use a little bit in the Young Dolph case. They definitely used it in the YSL case. I don't think that's a good precedent because I literally just wrote a pretty serious song. I say serious. I say serious, right? Yeah, yeah, like send it in the chat. What are we sending it for? Send what? Put send it in the chat. What are we sending? Oh, okay. Oh, cut and paste and send it to you. Okay, I got you. Oh, say less. It's yours. It's yours. Say no problem at all. We Watch YouTube is a fantastic creator, by the way. Oh, I got you. Don't say less. Say less. You will have it in a moment. But my point in bringing that up is I do think it's a slippery slope. There's no way that you can prove that I wrote those lyrics. I didn't. ChatGPT did. Now I'm gonna take credit for it. I'm gonna collect the royalty check for it. Absolutely. But why would you so I'm supposed to go to jail because I wrote these lyrics or I claim responsibility for these lyrics? How do I know that Tyrone the ghostwriter didn't write it? Like this is just such a bad precedent. I don't think that they think about this, and I don't think they're being argued properly. So I just think that needs to happen. I think that somebody needs to argue these things more robustly, if you will. It needs to be argued out in a way that, because again, I don't think that that's the right way to handle it. But anyway, I got it. I just sent it to you. We Watch YouTube. It's yours. I gotta rap it a little faster. I was rapping at a pace I could make sure I stayed up with it. I didn't want to be out of step. So it's the first reading. It's my first reading. Give me a little bit of grace. Now We Watch YouTube is gonna make it slap. So there's that. And then I'm gonna post it, and then I'm gonna collect the royalties, and I'm gonna get brought up on Rico, and then I'm gonna be like, when We Watch YouTube did it, but I put it in Chat GPT, and it's gonna be crazy. It's gonna be crazy. Y'all, thank you so much. I appreciate y'all. This has been a lot of fun. Let's do this again on tomorrow. Have we decided if there's court tomorrow? I don't know. I don't see anybody saying otherwise. So keep your eyes on the community post. Keep your eyes on the subscription channel. You'll see when I upload the thumbnail, all that kind of good jazz like that. I really appreciate y'all. It's been a lot of fun. So tomorrow we got Doug coming in. We hopefully have court tomorrow. We'll have Doug coming in at 7:00 p.m. Eastern Standard Time. Drop your questions down in the comments. I'd love to chat with you all and give his questions to you so you can get some questions answered. Hopefully it'll be here as long as y'all will have them, which should be fun. And I'm looking forward to it, y'all. So thank you again. Every last one of y'all. Y'all rock. Appreciate you. I'm gonna go and harass the dangerous crew since they're harassing me. I might as well extend the courtesy. I appreciate y'all so much. Hey, let's do this again real soon, everybody. Grace and peace. Take care.